And we are recording.
Okay, great. So let's call the meeting to order. December 2nd, 2020, 4:34 p.m. So roll. Item number 1.
I'm sorry, I didn't hear you, Chair Wolf.
I said calling the meeting to order December 2nd, 2020 at 4:34 p.m. Please call the roll.
Okay. Member Hensy? Member
She's
Hensy?
muted. Fiona, you're muted.
All right, let's move on. Vice Chair Yankee?
Present.
Vice Chair Yankee present. Member Highland? Member Highland?
He's on the phone.
I might have
He's
muted Mr.
transferring
Highland.
from.
Please press *6 to unmute
Okay.
yourself.
Member Highland?
Here.
Member Highland present. Member Hensy?
Present.
Member Hensy present. Member Schmidt?
Present.
Member Schmidt present. Member LaHood?
Present.
Member LaHood present. Member Wong?
Present.
Member Wong present. Chair Wolf?
Present.
Present. We have a quorum.
Great.
Bruce, there's kind of an echo when you speak. I don't know if anybody else is hearing it.
Anybody else hear an echo from me?
Yeah, it's almost as if your connection is like very, very poor. Like you don't have enough bandwidth or something.
Could be. Been having problems with Microsoft Teams all day. I'll turn down my audio a little bit. Maybe that'll help.
That's a little better.
That's a little better,
Okay.
yeah.
Great. All right. Let's move on.
There it is again. I'm still hearing it, Bruce.
How about now?
That's a little better.
Okay. Well, you'll have to deal with it the best you can do.
Shall I read remote access information?
Is that better? Can you hear me? Can you hear me?
I can hear you, but there is yeah. Member Wong is correct. It's
Like it's
difficult
distorted.
to. Yeah, it's distorted.
Is that better?
No.
No. How about now? Is that better? Hello?
A little better.
Hello? Is that better?
It's better, but it's very quiet.
Very quiet. And how about now? Is it still very quiet? Still testing
Loud.
1, 2. Oh, shit. So annoying, this Microsoft Teams. Gotta be honest with you. Can you hear me at all?
Yeah.
We can hear you.
Oh, you can. Okay, maybe I'll just speak up a little bit. Okay, so yes, please speak the remote access information.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London Breed proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. The Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Did you want me to read meeting decorum, Bruce?
Yes, please do.
Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave.
Let's call next item.
We did call the order and roll call, but we did not discuss agenda changes.
You didn't what?
We did not discuss agenda changes in item 1.
Right. That's fine. We can do that right now. Any changes or adjustments to the
Okay.
agenda?
Yes, I just want to inform the committee that today, TCA Price Wolf was not able to provide a conclusive report to the committee on file number 19058, and that matter will be continued to the January 2021 hearing.
Okay. Let's call next item.
If I could,
Yes.
Bruce, if I could
Sorry,
just speak
public
to that real
comment?
quick.
Sure.
I just wanted to apologize to the task force. I had all intentions of getting you guys a memo ahead of time. I've been working I don't know if you got the email I circulated. I've been working pretty diligently. It's a complicated, lengthy issue. So it's not for want of effort or time spent on it. Just wanted to assure the task force of that. And I gave Bruce my yes exclamation point assurance that you'll have it by in time for January's meeting. So I just wanted you to hear that from me.
Very good. Thank you.
Thank you, Price Wolf. Item number 2.
Yes, please.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force November 4, 2020 and November 10, 2020 meetings.
Okay.
Anybody have any
or
changes?
adjustments?
I have a hard copy of everything right here, so
Look good to me.
Any changes or adjustments to the minutes? If not, let's get it on the floor. Let's get a motion.
I'll move to approve both sets of minutes.
I'll second.
Lila?
Moved by
Yes,
by
Lila.
moved by Vice Chair Yankee, second by Member LaHood. Public comment on either of the minutes.
Yes, please.
Hang on.
Hello, my name is Winston Hillier. I'd like to make public comment.
Hi, which of us is going first?
Wait for Cheryl. When she's getting ready to get the clock.
Yeah,
Ready.
who's gonna go? Who's gonna go first?
I heard. I believe it was anonymous.
First. Yeah. Okay. Go ahead,
All right,
Anonymous.
let me know. Thank you. This is with regards to P3 of November 4th, the regular meeting minutes. I guess it's page 2 of the minutes and P3 of the footer page number. This is with regards to the presentation of the annual Supervisor of Records report. I had submitted a written comment regarding this. I was not able to attend the task force meetings for various issues, and I don't see that comment. I submitted it in writing, and I will tell it to you right now. It is that Supervisor of Records report is false, and that you should not have accepted it because it includes a petition that they did find partially in my favor, and they claim that they, in the summary that they submit to you, they claim that they found completely in the SFPD's favor. Thank you.
Okay, next speaker.
Thank you, Mr. Chair. My name is Winston Hillier.
Hang on.
Okay.
Go ahead, Mr. Hillier.
Thank you. With respect to item number 3 of the minutes of the special meeting of November 10th, I do not believe that the minutes completely reflect what occurred relevant to this item. I had been disappointed when I saw the agenda for the meeting of the Compliance Amendments Committee of November 24th because it did not contain this item. And now that I see that the minutes for the November 10th meeting of the Sunshine Ordinance Task Force, I understand why. We do not show that item number 3 was re-referred to the Compliance and Amendments Committee, nor anywhere else. Consequently, it is dead or in limbo. Yet, this is not what I recall occurred during the meeting. During item number 4 on November 10th, the general public comment item, I challenged the chair for not requesting a vote on item number 3, because as I understood it, the item had been re-referred to the Compliance and Amendments Committee. Vote or no vote, however, the item had been re-referred. This may be ascertained by the fact that no one raised any objection to the re-referral, and the chair moved on to the next item. In support of this, I cite Rules of Order newly revised 12th edition, the parliamentary authority for the task force cited in Bylaws Article 5A. Rules of Order cites as a, quote, fundamental principle of parliamentary law, end quote, in paragraph 5:4, and I quote, once a motion is before the Assembly, it must be adopted or rejected by a vote, or the Assembly must take action disposing of the question in some other way before any other business can be introduced, end quote. The motion was disposed by a subsidiary motion to refer it either to the Compliance and Amendments Committee or, as the minutes seem to suggest, to staff. Either way, the minutes must reflect it, and I quote Rules of Order paragraph 48:4, subparagraph 7 as follows, and I quote, the body of the minutes should show secondary motions that were not lost or withdrawn in cases where it is necessary to record them for completeness or clarity, end quote. Although it is correct that, quote, no action was taken on this item, end quote, as appear in these minutes, according to the definition of action taken in Government Code section 54.952.6, the minutes should also show that this item was successfully referred either to the Compliance and Amendments Committee or to staff. And if to the Compliance
30
and
seconds,
Amendments
sir.
Committee, I ask that it be agendized for the next meeting thereof. Back to you, Mr. Chair.
Thank you. Any other public comment on either of the minutes? Okay, seeing none. Just want to respond. So, Cheryl, if you would please retrieve Anonymous's written statement and include it in the minutes. That would be good. I remember he provided a written statement, and that should be reflected in the minutes. And as far as the other item is concerned, I just want to say while I understand about parliamentary procedure in regards to Robert's rules, we have our own set of rules with regards to orders of determination. Once the order has been made, it is pretty much automatically gets monitored by the Compliance and Amendments Committee. That's where the first place it goes to. It could be any other committee from the chair. It doesn't have to directly be referred to by the chair to the committee. That's the way our complaint procedure is written. So with that, any other changes or adjustments to the minutes, members? If not, let's call roll.
Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Wolf? Member Wong?
Oh, sorry, I didn't hear. If that
Member
was
Wong?
Wolf or Wong.
Wong, I'm
aye.
sorry. Member Schmidt?
Aye.
Member Schmidt, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Looks like he's frozen.
Chair Wolf?
Aye.
Chair Wolf?
Aye. Aye.
Chair Wolf, aye.
Aye.
Heard you. I heard you. Motion to amend the minutes passes.
Okay, thank you. Please go on to the next item. Yeah, let's go on to the next item.
Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, since we're running a little bit quick here, we'll start with public comment for those that are here, and then once 5 o'clock rolls around, we'll, if we're done, we'll wait and see if anybody else shows up. So this is the call for general public comment for items that are not on our agenda today, but are within the task force's jurisdiction.
Anonymous here, but I'll let someone else go. Anyone else who wants to go first. So.
Any public comment? Okay, since there is no, yes, any public comment?
Yeah, sorry, I said anonymous, but I'd let anyone else go first. That's all I said. Nobody else wants to go.
Well, please unmute yourself. Star 6. Unmute yourself if you want to speak under public comment. Star 6. Okay, let's start with our first speaker then. Whoever steps up.
All right.
Cheryl.
This is anonymous. Let me know when to begin. All right. I'm going to give you a paraphrasing of a speech I gave to the Board of Supervisors last night. And here it goes. Good evening, supervisors. You may know me as Anonymous, and you've probably ignored many of my emails about sunshine and transparency. Now, by chance, I happen to be the person who requested the interagency text messages of senior officials throughout the city, including Breed and Scott, that were discussed at the start of this meeting. In that episode, Chief Scott produced to me copies of his text messages, which contained orders by Mayor London Breed to engage in various police activities regarding homeless persons. Whatever you may think about Breed's policy, the public has an Article 1, Section 3 constitutional right to know what Breed and Scott were doing. What you may not know is that Mayor Breed's office claims that she has no copies of these orders issued to Chief Scott by text message and has produced none. Is her destruction or failure to retain these records ethical or transparent? You have the authority to ask her. Her office has previously testified, Mr. Heckel did this a while back, that Sean Ellsburn destroys his calendar entries every 2 weeks. Is that ethical or transparent? You may also not know that in June, I requested the text messages between Harlan Kelly Jr. and Walter Wong. Initially, the PUC produced nearly all of the text messages to me. Then they requested that I delete the production of these records. As I was surprised to learn this morning, which was yesterday morning, many of the topics in the complaint published by the Department of Justice against Mr. Kelly are directly related to the text messages the PUC now refuses to disclose to the public. I want to be clear. I have no clue whether Mr. Kelly is guilty or not of any alleged crimes, and the discussion may be innocent, but it is about those topics. But there is no lawful reason for the city to now suppress disclosure of the Kelly Wong text messages. The people have the right to know. And the rest of this is not really relevant to this task force. Thank you very. Oh, actually, I do want to say one thing. The clerk's office at the full board, they have a much nicer system for queuing up public comment. I hope you guys can implement it here. I assume you have the same technology as the full board does. Thank you very much.
Next speaker, please. Any other speakers for public comment? Please unmute yourself by pressing star 6. Okay, seeing no other public comment, we'll close public comment. Move on to our next item.
Item number 5, file number 19103, complaint filed by Anonymous against Mayor London Breed Hank Heckel, in the office of the mayor for allegedly violating Administrative Code sections 6721, 25, and 26 by failing to respond to an immediate disclosure request in a timely and or complete manner. This matter was heard before the Compliance and Amendments Committee, November 26th of 2019. It found jurisdiction, the records are public, and referred to the task force for hearing.
Very good. Okay, Cheryl, you ready with the clock? Okay, and let's make sure both parties are here. Is Anonymous here?
The petitioner is here. Thank you.
And is the respondent, Mr. Heckel, here?
Okay, I'll start the clock whenever.
One moment. Just checking to see if respondent is here. Somebody from the mayor's office here. Please unmute yourself, *6, if you're on the phone.
If I may, Mr. Heckel was just here, so.
Yes, he was.
He was, yeah.
Hello?
Mr. Heckel, are you here?
Yes, this is Hank Heckel, appearing on behalf of the Office of the Mayor. Thank you.
Very good. Okay, great. Okay, let's start with our petitioner. Cheryl, let me know when the clock is ready.
Go ahead, sir.
Thank you. Please let me know at 30 seconds. Good evening, task force members. This is case 19103 Anonymous versus Mayor London Breed, Hank Heckel, and the Office of the Mayor regarding future calendar information. And there are many copies of my presentation in the packet. The correct updated version of my presentation is on PDF page 106 or footer page P228. The other ones are very old. So in this case, on October 4th of 2019, I made an immediate disclosure request for 1 week of calendars intentionally a few weeks in the future. On October 7th, that was a timely idea response because there's a weekend in there. The records were fully withheld by Mr. Heckel under Government Code 6254F, and he stated, quote, security procedures information of a local police agency, end quote, a rule of reason analysis, end quote, without any legal citation. I immediately filed complaints. A month and a half later, Heckel added a citation to the infamous Times Mirror versus Superior Court case we're going to talk all about today. The thesis is the mayor cannot completely withhold any future meetings. She must provide whatever entries exist at the time of the request with minimal redactions, and you have held in this exact same manner in previous cases 18075 and 19112 versus the district attorney and the police chief. However, Mr. Heckel says that unless you hold this against the mayor herself, because her position is different, they're not going to comply. And on all of the dates relevant to this request, the suspensions of the Sunshine Ordinance were not had not occurred and are not relevant. You can see a summary of the exact request that is at issue here on the second square below here. Next page, please. The mayor's future meeting information, somebody's making noise, by the way, is not entirely exempt under Government Code 6254F. This exempts, quote, records of, security procedures of, any state or local police agency. We know from other records that she has essentially a secret service called a Special Investigative Division. Records of all of those entries are properly exempt under this exemption. Nothing else is, whether in the past or in the future. The city must redact only her security detail information, which is a procedure, a security procedure, and must provide everything else. Now, you have heard this citation from many other people before you, in fact, your committee as well, about a case called Times Mirror Company versus Superior Court 1991. And this cannot exempt this record for many reasons. One, it exempted the governor's past calendars. In San Francisco, the past calendars are public. Two, governors get special explicit protection in the CPRA. Mayors do not. Three, the ruling does not cite Government Code 6254F. Fourth, the Supreme Court's conclusion relies explicitly and solely on Government Code 6255, which is a catch-all balancing test, which is prohibited locally by SF Administrative Code 6724G and I. And you can see the direct quote where they state 6255 is how they come up with this conclusion. That's the Supreme Court's words, not mine. But most importantly, Times Mirror Company exempting calendars is bad law within the state of California because of Proposition 59. The First Amendment Coalition sued then Governor Schwarzenegger immediately after this proposition was passed, in a pretrial settlement, the governor did turn over his past calendars. Remember, the future was never relevant to those other cases. So Times Mirror just doesn't matter. Next page. These are the records. I want to be clear. These were not provided in this request before the dates occurred. I had to make a separate request, and I did afterwards, and this is what they gave me. Do every single word on this page constitute a, quote, security procedure of the SFPD? If no, you must find in my favor. Nothing in here is a security procedure. And even if you were to argue that something on here is a security procedure, such as the location of where the mayor would be at any given time, the statements of topics are not. And this is not a Prop G calendar, I don't believe. This is the non-Prop G calendar, the one they make beforehand. This stuff about airports and courtesy calls is not a security procedure of the SFPD. It is, however, her deliberative process privilege. As you know, even under the COVID rules, deliberative process privilege is banned here. They cannot hide this information. And next, final page, I have a copy of a transcript from between Hank Heckel and Chair LaHood, where Chair LaHood asked, why didn't you release all of it? Mr. Heckel said, without the dates, times, or places, maybe there's something that can be disclosed, such as the topics that were going to be discussed. The exact quotes is here. In my rebuttal, I'll discuss all the various violations I would ask you to find. I asked you to give them the time to do any more citations. There are appendices and more pages of why every single citation they have is wrong. Thank you.
Thank you. Are any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Please unmute yourself, *6. Okay, hearing none, let's hear from the respondent. Mr. Heckel?
Go ahead,
yes,
sir.
This is Mr. Yes, can you hear me?
Yes, go ahead, sir.
Good evening, Chair Wolf, members of the task force. I'm Hank Heckel, appearing on behalf of Mayor Breed and the Office of the Mayor in response to Anonymous's complaint in this matter. Our original position that the mayor's future calendar entries cannot be disclosed due to security considerations remains. We set forth our position on this issue in the hearing, which the original complaint committee hearing on this was held quite a while ago, and I think there's been a backlog due to COVID, so we discussed a lot of these issues almost a year ago. But in sum, the disclosure of information concerning the particulars of the mayor's upcoming non-public meetings, including date, time, and location, poses a security risk by jeopardizing the safety of the mayor and confounding the ability of the San Francisco Police Department to provide effective security procedures for those meetings as it is charged to do. Accordingly, at least under Public Records Act, Section 6254F, records of the calendar and schedule for future meetings of the mayor are exempt. Under 6254F, records of concerning the security procedures of a local police agency may be withheld from disclosure. That provision is not abrogated by the local sunshine ordinance. That is still in effect. And to put some background on this, the mayor as the chief executive of the city and county gets security from the police department. There's a special investigation unit of the police department that provides that security, and they attend to every official meeting of the mayor. So all of the mayor's upcoming meetings require those members of the PD to plan, to implement, to schedule personnel, and to devise and implement procedures to provide for the safety and security of the mayor and anyone meeting with the mayor. Future calendars provide information on when the mayor will be arriving at and departing from specific locations, person she is with, or time she may be unattended. All of this information could create a security risk if disclosed. Providing these details in advance of the meetings compromises the PD's ability to do their jobs and provide security for the mayor, and reveals information that may be misused by those seeking to disrupt meetings and potentially pose harm to the mayor and others. We also believe this position is supported by the Times Mirror case, as Anonymous pointed out, which is still good law, and which did relate to the calendars of the governor of California. However, the rationale is just as applicable here. The rationale of that case was based on the balancing test of Public Records Act 6255, which we understand is limited by the local sunshine ordinance. However, the rationale of that case fits just as easily here under the rubric of 6254F in regard to security procedures. In that case, the California court said that the governor's daily and weekly schedule set forth in exhaustive detail the particulars of the meetings and travel of that official. The official in question here is, of course, the mayor. The time and location of arrivals and departures, traveling companions, hotel accommodations, and ground transportation. As the court stated, the revelation of such information would seriously impair the ability to assure the, in this case, mayor's security, and would constitute a potential threat to the mayor's safety because the information will enable the reader to know in advance and with relative precision when and where the mayor may be found, those persons who will be with the mayor, and when the mayor might be alone. Now, I think there's an important distinction to be made here because bear in mind, we do have complete transparency around the mayor's meetings that actually occur.
30 seconds, sir.
Those meetings are disclosed. They're memorialized as required by law in the mayor's Prop G calendar, which we maintain faithfully. That records all of the mayor's meetings, the attendees, dates, times, locations, descriptions of those meetings. We make those, we keep that calendar, we make it available upon request, and we honor all requests for the mayor's past meetings. However, our concerns regarding future meetings.
Time's up, sir.
Okay. So I'll be happy to take any questions the task force has. Thank you.
Are there any persons or witnesses providing additional facts or evidence on behalf of the respondent? Okay, hearing none. Okay, members, this is time for question, Q&A, clarifications on the merits that have been brought before us.
I have a question.
Member LaHood.
Yes, Mr. Heckel, why didn't you release other information about the substance of the meetings without revealing the locations?
So the original request, as I understand it, was for the mayor's calendar. And so, we're not able to parse out. I mean, the calendar is in the form of what we all understand to be a calendar that lays out that, dates, times, et cetera. Moreover, I think the initial request was for a fairly narrow window of time. So if he's requesting, meetings for December 15th of this year, say, and we reveal those.
Time for that to get booked. Just put it in.
Can we please have, hold on a moment. Please, can we have everybody please mute by pressing *6 who's on the phone? We hear lots of background noise. Thank you. Continue, Mr. Heckel.
Thank you, Chair. Yeah, if I could just finish in response to, I believe that was Commissioner LaHood. And so if we were to disclose, calendar entries for a narrow window of time, say a couple weeks from now, by revealing the details of those meetings in terms of the attendees and the subject matter, that could tip off someone with sort of reasonable certainty, even though they might not have the exact date and time, that a meeting is occurring in that week. And so to the extent someone wanted to disrupt such a meeting, that could complicate the security procedures necessary to save.
So are you saying then that if the request was for hypothetically December 5th, you would not want to say who the mayor was meeting with, but if the request was for future meetings in all of December, you would have released that information in aggregate?
I mean, I don't know that would go that far. I think that the narrower the window, in some respects, the more difficult it becomes. But also, you asked about whether the location, could be redacted. But I mean, of course, in pre-COVID times, almost all of the mayor's official meetings are conducted in her office at City Hall, so it's sort of no, there's a secret as to the location of those meetings. So to reveal other particulars for certain periods of time may provide information to persons seeking to disrupt those meetings or otherwise cause security concerns.
Yeah, I think this is member
Henry.
That was my question: is could you not just redact the location of the meetings, obviously in pre-COVID times? But I think, is that your answer? Is there anything you want to add about redaction?
No, I mean, I think that sums it up, and I would say, even during the sort of COVID era with all the restrictions, I mean, there is limited, city work that still takes place in city offices, including City Hall. So, I wouldn't say that it's the case that meetings don't take place at City Hall anymore. In some instances they do.
Yeah.
And so
May I be permitted to? I apologize.
Just a minute.
Yeah,
just a minute. We'll get to you. We're not going to have a real-time debate here, and rebuttals will come, but I'm sure there'll be lots of questions. So we'll get to it. Go ahead, finish, Mr. Huckle.
Thank you, Chair Wolf. So I just think there's a lot of logistical difficulties, even with attempting to redact the calendar in a meaningful way. I mean, I think if he's not requesting just kind of a list in the vacuum of meeting subjects without any context of date, time, or place. I mean, I wouldn't even think of that as a calendar, and it's not even really a document that exists. The document that exists is the calendar, which you can parse out the overall dates: Monday, Tuesday, Wednesday, Thursday, Friday, etc., and you can ascertain information that we maintain poses a risk to the security procedures. Yeah.
Okay, Member Hensy, Member LaHood, anything else on this subject?
Question.
Yes, go ahead, Member Schmidt.
Yeah, to follow up on those questions and answers. So when you were saying, Mr. Heckel, you saying that there would be logistical difficulties? Could you give me a little more explanation of these logistical difficulties that you believe justify not producing the calendars?
Well, I guess it depends on what specifically is being required to be disclosed. When anonymous requests a calendar, we kind of understand it to be the traditional, common usage of the word calendar. So that if you request, even if you were to request, say, all of December 2020, I think by looking at that document as it exists in the grid format of the calendar, you could redact out the names of the days of the week and the specific dates, but you'd have a pretty good snapshot of, okay, the mayor's meeting with these people, if he is requesting the identity of attendees, and the mayor is addressing these topics in this sort of 4-week or however long a period of time it is. And so I do think that someone that was seeking to disrupt a meeting like that, or wants kind of advance notice of who the mayor is meeting with, and what about, that could create security issues, because you could sort of ascertain, kind of in this window of time, these meetings on these subjects are taking place. And so I just don't know how you...
What do you mean by security issues? What's the security issue that is going to be presented by someone knowing a meeting is going to happen?
Well, if someone wanted to disrupt a meeting,
Someone wanted, how would they, how would they disrupt a meeting like that?
Well, they could storm into room 200 and try and raise some kind of issue. I don't, I mean, there's all kinds of scenarios. The mayor, the mayor provides.
What are the other scenarios?
Because of security concerns for the chief executive of the city.
You're saying that you're speculating that some unspecified person would storm into room 200 because they know that a meeting's happening.
I mean, that's right. I mean, that goes to the heart of the entire basis of the Times Mirror case, which is still good law. So we believe the rationale fits under 6254F exemption that protects the security procedures of a police agent.
I agree that to some extent Times Mirror is good law for this factual situation. Now I have a question for Anonymous. Could you just give me a description of what you did, if anything, in terms of caliber? Did you get nothing? Did you get anything redacted? Or what did you receive?
Sure. Yeah, I just want to say it's almost impossible to hear what you or Mr. Heckle are saying. There's an enormous echo, and I would please request to the chair to request whoever it is mute whoever is doing that. I can't hear almost anything. Could you repeat the question? I heard something about did you redaction, and that's all I've heard.
Let me try.
Let's hold on a second. Let's just let me just halt the proceedings for a second and speak to our administrators. Is there any way that you can manually mute all the phone-ins except for Anonymous and Mr. Heckle? Okay, I think it's happening now. Okay. All right, well, let's continue.
Bruce, I'm still hearing an echo.
Still hearing an echo. Okay.
Yeah.
How do I sign up, Cheryl?
I will mute. I don't know, maybe me, because I've been having lots of problems. Let me mute.
Sorry, this is Anonymous. Someone muted me. I've unmuted myself, just stating that.
Okay. Let me see. Anonymous, this is Tim Schmidt. Hopefully this will be better, although I'm hearing a slight echo. Yeah, my question is just, what did you receive? If you in response to your request, did you receive nothing, or did you receive anything with action?
Thank you. On October 7th, when they responded, they fully withheld all records. And the specific request they responded to is at the bottom of page 106, which is page 228 on the footer. I did not request the grid calendar. That's false. You can read what I requested right there. They've given me these detailed individual page entries many times. What he's saying is false. You can see the kind of records they gave me later on. I don't want the grid calendar. That would show me the date. But I said the title. They could have given me the title and kept the other stuff out.
Okay. Thank you. No more questions for now.
I have a question for Mr. Heckle. Can you hear me okay? Hello? Can you hear me?
The audio is a little garbled.
Is that better? No? Good. Okay. Is that better? Can you hear me?
Better.
Hello? Better.
A little better, yeah.
Okay. Mr. Heckle, how does the mayor deal with passive meetings?
Chair, is that Chair Wolf? Or,
Yes.
The question, how does the mayor deal with passive meetings?
Correct.
You mean like the meetings of a passive meeting body?
Correct.
Right. So I also just want to be specific in what I'm saying here. So I think the issue we're disputing is non-public future meetings. And so to the extent that the mayor has an appearance that is going to be in, say, a forum that has open meeting requirements, that information, I guess, theoretically could be disclosed. But certainly, if the mayor is going to appear at the Board of Supervisors as a policy body, or perhaps he could appear at a passive meeting body, the notice provisions, would apply in that instance. And so I think that all of the open meetings requirements would normally be complied with by that body. And of course, there's many public events that the mayor has that are not necessarily subject to open meetings laws, but are, say, press events or kind of announced public meetings. And there is a press calendar that does get posted on the mayor's website. And so occasionally there are, some upcoming public meetings that could be disclosed. Our position is, to the extent that there is non-public meetings, which the mayor obviously conducts quite a bit of business at City Hall in her office, on various issues and with various attendees. The security procedures of PD are important and should be safeguarded. That's the focus of this dispute, as opposed to these other public meetings which are disclosed in advance. So that's I don't
understand. In the course of the business of the mayor working for the people, for whatever hours of the day that is not private, are you saying that there are some meetings that you would not disclose?
No, I mean, every meeting of the mayor is disclosed on the property calendar within 3 days of the meeting by law. We basically do that.
Yeah. And so I'm a little confused here. The information that the petitioner or the requester was asking for, what part of the calendar entry was are you really seeking to protect?
We're seeking to protect the details of future meetings of the mayor that have not yet taken place, that are non-public meetings, that are subject to SFPD security procedures.
All right. So just the announcement that she's having a meeting with the police department, you would not disclose that?
So it's not limited to meetings with the police department. It's any future non-public meetings, because all of the mayor's meetings are attended to by security provided by the SFPD, regardless of the subject. All of those future meetings, we're saying, should not be disclosed under 6254F, and the rationale of the Times Mirror case, in which future calendar entries of the governor were withheld on similar grounds. But of course, past meetings, once the meetings occurred, those are not secret. There are no, secret meetings. Once the meetings occurred, it's on the property calendar. And so if you wanted to request something that occurred, last Friday, that would be on the property calendar, and we would provide that in response to a records request. But we won't provide these future meetings before they've occurred due to the security concerns.
Okay, thank you. And to the petitioner anonymous,
yes, sir.
Your contention is that the future meetings are disclosable.
I contend that at least some portion of that page, I'll be very specific, on page 108 of the PDF, which is page 230, footer page number, these are 2 calendar records that they later gave me on a different request for the date span that was in this request. They could have removed the location, they could have removed the start and the end, the recurrence pattern, whatever else, and all they could have given me was the phrase courtesy call with Professor Dr. Eckhart Wirsner and quarterly meeting regarding airport update, and that would have been a minimal withholding, because it would not, those words do not constitute a quote security procedure of the police department, even if you agree, let's say with his now argument, which is kind of all of the other information could tell you what the mayor's up to. Kind of knowing that the mayor generally has meetings doesn't implicate anything. We already know that. And then the second argument is about Times Mirror, that in Times Mirror, they exempted, I would like you to ask Mr. Heckel to give you the line and like a legal citation in Times Mirror to what he's talking about. What they say in Times Mirror, and I entered it into the document here, is that the past governor's calendars can't be known because you would find a pattern from the past calendar entries to predict where the governor would be in the future, and on the balancing test, that would be, that weighs towards non-disclosure. And how they're using it here is saying, by knowing the future meetings, you would know, where the mayor would be. And like I said, even if you consider the security risk to be the date, time, location, I did ask for the subject line, and they could have removed everything else and given me the subject line, and all we would know are the topics and not the procedure, and that would suffice to know what the mayor is talking about, which is only a deliberative process and not a safety issue whatsoever. Those sentences could have given me and redacted the whole rest of the page. Thank you.
Okay, let me ask this question. It probably has been asked before. Did they provide you with any full redacted pages?
No, I'll show you the exact response because I don't want to, make any error here. The full exact response, or at least you can see it, is on page, the bottom of page 120 of the PDF, which is page 242 of the footer. On the bottom, it says on October 7, 2019, Dear Anonymous. Then you can see their reasoning, and then you can see on the kind of continues Heckel's response, and it says it jeopardizes the safety and security, etc. You can see that.
Okay.
Yeah.
So thank you. So back to Mr. Heckel. So you didn't provide him with any information.
That's correct.
Okay.
He asked for the calendar and the schedule information for those dates, and we withheld it on the grounds that we've discussed.
Do you consider the calendar to be not a public record that can be withheld?
No, it's not our contention that it's not a public record. Our contention is that it's a public record that's exempt from disclosure.
The information that's on it may be exempt from disclosure, that you could use redaction. That's the purpose of redaction. But withholding the document itself is not lawful.
Well, if the entirety of the document is exempt, there's nothing to redact. There'd be nothing to provide.
That's not true. No, that's not true. If you take the case, we've done this before many times. Okay, you have a some sort of investigation. There's a file. The entire file, physical file, can be withheld under the investigations evidence code. Okay, but any other public record cannot be claimed at the same level of exemption for withholding. It has to be produced with redaction, much in the same way we just saw Supreme Court documents being released. The pieces of paper are public records. They have to be released. You can black out the whole thing. The FBI does it all the time. Same difference. If the record itself is public, it must be disclosed. For a calendar, there is not an investigative record. It doesn't fall under the evidence code at all. You're using a balancing test for a matter of security. Okay, I get that. We'll deliberate that further, but I don't see how withholding the record itself is applicable. It's not in compliance with the law. Now, if you supplied it and it was completely redacted from header to footer, then the requester can come back and then state, okay, where are the footnotes for each of those redactions, which is required under the ordinance. So, I'm a little confused. So, even if you use times, the times case, it still doesn't apply with regard to this. And so I'm a little concerned about that. It's not suspect.
May I respond?
Yes, go ahead.
So our position is that the entirety of the record is exempt from disclosure. So I kind of understand what you're saying about redaction, but our position is not that portions of the document are exempt. Our position is that the entirety of the records are exempt. So in the same way that when the city attorney withholds documents on the basis of privilege, they withhold the entire document.
That's different, sir. Come on. You know as well as I do, records that are held under privilege is under a completely different set of law, completely different rubric. That's not applicable at all, really. This is a public record that's under Prop 59 and in the ordinance itself and in the CPRA. It's a calendar. It's a calendar. Okay, it's not litigation material. It's or evidence. It's not you can't apply it that way. I will contend to ask, under which area or section under times, the times case law, that you are applying this.
So yeah, respectfully, it is our position that it is analogous to withholding something for privilege. That privilege material is exempt in the same way that we're claiming exemption here, and therefore we're withholding the entirety of the document. But with respect to Times Mirror, if you're looking for a citation, so the case talks about withholding the governor's records of upcoming meetings, and talks about how the disclosure of such information, quote, it is plausible to believe that an individual intent on doing harm could use such information to discern activity patterns and identify areas of particular vulnerability. And that's at Times Mirror 53 Cal 3rd at page 1346. And that section of the case lays out sort of argument around the security concerns that's factored into the court's analysis, the Court of Appeals analysis, and upholding the exemption of these types of materials for, in that case, the executive was the governor. We argue the same rationale applies here to the mayor.
Okay, thank you. Members, any other questions, clarifications, or we move to rebuttals?
I have a question.
Go ahead, Vice Chair Yank.
Mr. Heckel, the part I'm confused about here is, or maybe you can explain, is the local police department involved or notified when the mayor has a conference call from her office? Or a courtesy call, let's say? Like, for example, I'm looking at one of the records that was turned over. Looks like in a subsequent request, but it says courtesy call with Professor Dr. Eckhard Versner, Mayor of Heidelberg, and it seems to take place in the mayor's office. So I guess I would be confused about how the local police would have been involved in that particular meeting.
Sure.
Are they notified when the mayor has telephone calls?
Yes, they are member Yankees. So the mayor, the PD security unit that attends to the mayor is present with the mayor essentially at all working times. So if the mayor is having in-person meetings or doing meetings by phone in her office at City Hall, the PD security detail is always present in the mayor's office, on site in the suite, basically. So all of the schedule, all the sort of planning of the schedule implicates the procedures of the PD. And then, of course, if the mayor was to move to another location for a non-public meeting, the members of the security detail would travel with her.
So is your contention then that even future planned telephone calls represent a security procedure from the local police department?
Well, I guess our position is that all of the future meetings all necessitate police security, and therefore anyone wishing to intervene in, disrupt, act in a way that is, poses some kind of risk to the mayor, or, even just sort of encounters with the security. All of that implicates the procedures of the PD because they're always present, sort of at arm's length, so to speak, during those meetings, whether they're by phone or remote or, in person.
So I guess that's where I'm having a little problem following with these policies. I mean, I can understand to a certain extent your contention that there might be, concerns about knowing the location the mayor's going to, because the police have to go and there's security sort of set up with that. But if the police is always present in City Hall, I don't see how knowing she's going to pick up the phone at, let's say, 10 a.m. and call someone represents some type of new security procedure that's somehow invoked because she picked up the phone. I mean, like you just said, the police is there anyway. So I'm not sure of how she's signing documents at 9:45, but then 15 minutes later picks up the phone, somehow triggers a new security procedure. That's where I'm having trouble with. I mean, to me, some of these clearly seem like they would not involve a particularly special security detail that goes along with them. For example, like this telephone call. I guess you don't need to respond to that. That was just, maybe going off a little bit, but I'll leave it at that.
Yeah, I mean, I'm happy to respond. I think I see the point you're making. I guess our point is that, the specifics of the meeting, whether, if it's a telephone call, it could be of particular interest to someone wishing to disrupt that meeting. So the revelation of that information in an upcoming meeting could sort of implicate the procedures of the PD because they want to increase security, or, they're just sort of made vulnerable to, persons interested in that information.
All right, I'll leave it at that.
I have
Member
a
Highland.
question or two.
Hold on. Member Highland first. Chris?
That's okay.
Yeah.
My question's been answered.
Okay. Member Schmidt.
Okay. Yeah, Mr. Heckel, you've talked about Times Mirror. Would you agree that Times Mirror is based on Government Code Section 6255?
I would agree that was cited in the decision. Yes.
It's cited, but the discussion of both the deliberative privilege and the security procedures, those were within the context of a 6255 exemption. Would you agree with that?
Yeah, I think it was within the framework of the 6255 analysis, but our position is that the same facts and logic of that analysis apply under 6254F. I mean, I don't think the court had to get to 6254F because 6255 is kind of a wider, broader exemption and will sort of kind of touch on both the deliberative process concerns, which we're not relying on because we know that's inapplicable under the Sunshine Ordinance, but it kind of also covers the security concerns that they had concerning governor's calendar.
So you're not asking us to allow an exemption based on 6255, but you want to use 6254, which was not what Times Mirror relied on, and yet also you want us to take Times Mirror as your authority. That's what I think I'm hearing. Is that correct?
Yeah, I think that's correct. I think it's 6254F is one point of authority, and I would argue that 6255 on its facts and on its rationale is also an authority in support of our position.
Although, what about the fact? What about the local ordinance which says 6255 is just it's not the law in San Francisco? How could you interface that? Do you think the local ordinance is not valid, or how does it work that you can rely on 6255 despite what's in the ordinance?
So, yeah, just to be clear, we're not relying on 6255. We're not challenging that provision of the Sunshine Ordinance. That's the law that the people of the city of San Francisco voted for, and that's what we abide by.
Okay. Thank you. That's all.
Members, any other Q&A? Are we ready for rebuttals? Okay, so let's start with the respondent, Mr. Heckel. 3 minutes to move on.
Okay, hang on a second.
Yes, thank you, members of the task force. I think we touched upon, some of the questions you had, and we've laid out our basic argument. I would also point out that the city attorney has essentially endorsed our position. The city attorney, through the supervisor of records, issued a response to Anonymous's petition on this very issue concerning the mayor's future calendars, and also decided that the calendars need not be disclosed based on 6254F in the Times Mirror case, and I believe it also cited the Evidence Code 1040 section on the official information privilege. And my understanding is also that the city attorney maintains that Times Mirror is good law. It has not been overturned. It has not been abrogated as suggested by Prop 59. We understand that Prop 59 is a significant ballot initiative in the state that has upheld, kind of enshrined the principle that sunshine exemptions and public records exemptions should be construed narrowly and access should be construed broadly. And I think as a general matter, we agree with that, but it doesn't specifically eliminate 6254F, and it doesn't specifically address security concerns relating to a chief executive detail around their upcoming meetings. Also, Anonymous mentioned that SFPD, I think there was a little bit of confusion earlier this year because SFPD had a similar issue concerning Chief Scott's future calendars. My understanding was that the representative for the PD at one point took the position saying, okay, we're not going to withhold the future calendars, but then came back and sort of clarified that that was a mistake, and the counsel for PD had advised them that they could maintain the exemption for future calendars. So, I know that issue's not before the task force, but that was a point that Anonymous has kind of thrown out there in support of his position. So again, we understand the balance of access and transparency, and that's why we're fully committed to the principles and practices of set forth in Prop G, whereby all of the mayor's official business on her calendar is memorialized in detail, and it is given out upon request once, after the fact, after those meetings have transpired, and in fact within 3 days of those meetings. But as future business, obviously the mayor conducts business on a range of issues that are important to the city, some of which, some issues are more sensitive than others. They could concern victims of crime. She meets with families and children, and, it is the goal of the Office of the Mayor to maintain a safe and secure environment in the mayor's
Sorry, your time
office.
is up.
Also at all of her meetings, and therefore the procedures of the PD need to be protected. And we don't believe that the details, revelation of the details of future meetings.
Sir, your time is up.
Yes, we believe that poses significant risks. Thank you.
Thank you. Okay, the petitioner, you have 3 minutes for rebuttal.
Thank you very much. So I think I'm going to talk slower and try to make my points better in this case. You have already precedentially determined, but not for the mayor, but for the district attorney and the police chief, these exact arguments did not succeed. It sounds like they're kind of changing their argument now. They're really relying just on 6254F as the citation, but Times Mirror for kind of a suggestive justification. So that's fine. They're not citing Times Mirror. They wouldn't be allowed to because of 6724G, H, and I. I urge you to read all three of them. It's not just 6255, but any balancing test and anything similar to a balancing test. So let's just go back to page 108 of the PDF, page 230, the P230 on the bottom. Do you think that when you constitutionally narrowly interpret the exemption of what a security procedure of a police department is that the word courtesy call is a security procedure? Is airport update a security procedure? Could they have done, as the chair stated, just redacted the rest and just give me footnote that the rest is all a security procedure? I urge you to really think about this. I think the people have a right to know what she's going to discuss in the future, even if they don't have a right to know where she's going to be, when she's going to be there. We're just talking about redact the security procedure, unredact everything else. And so I will go back to page 109, which is bottom footer page 2. I'm actually not going to ask you to do 2 and 3 because it doesn't seem like they're actually citing Times Mirror. This is just a 6726 issue. Could any portion of that record have been provided, any whatsoever, and could they have done redactions with footnote or clear reference? If so, you should find in my favor and ask them to only redact just the security procedures and give the other parts of future calendar records to me. I guess my time isn't up. EC 1040 does not apply here. There has to be a harm to justice, and London Breed cannot receive her own calendars in confidence. I don't know if you want me to spend time arguing these other random citations, but the real citation here is 6254F.
30 seconds,
really
sir.
Thank you. Really think, is every single word on page 108, which is P230, a security procedure? And if not, please rule for a 6726 non-minimal withholding violation. Thank you very much. I'm done.
Thank you. Okay, members, it is with us now. I see Member Highland.
Yeah. I have to say, having seen the record that was released on page 230, certainly there's no problem with the technology or the level of work required just to redact, a simple line or two. So that argument, whether they're making it is out. I'm not convinced by rule of reason. I'm not convinced by balancing tests. Those are all convenient words used when they don't actually have something to stand behind. So I very much agree with the fact that, and Mr. Henkel even said, yes, this is a public record. Bingo. That's all he needs to say. It's a public record, redact it correctly, and give the man what he's asking for. So that's my position.
Any other comments?
Oh, go ahead. Remember, did you? Oh,
no.
You go ahead. Go ahead.
Okay. Well, I mean, I actually sort of struggled with this a little bit because it is a complex legal issue. But I think what it comes down to for me is if the mayor's office had made the effort to, give something, but to just go through, spend some time, and take out those specific things that are, I guess, dangerous, etc., but leave in what the public really does want to find out, then they would be following the law. But to me, to just say, Times Mirror, nothing, you get nothing, it just doesn't cut it. And the idea that they don't have that, I guess it's a parsing out challenge or something like that. I don't think that works in modern government.
Member LaHood?
I agree with what Member Highland said before. I think this is clearly, we have a violation of 6726. I'm curious about whether other task force members think that we should pursue some of the other violations in terms of unlawfully citing. The Times Mirror case, I don't know if that's appropriate, but clearly the withholding was beyond what was necessary, and the documents should have been provided in the fashion with just the required redactions that were required for security and safety, and providing all of the other information.
I don't know about the unlawful citing, but I think it is an important case for this case, and so I can't blame them for looking at it. I mean, whether or not it applies, I don't think it really applies, but you do have to really read it to figure out why maybe it doesn't apply. So it's not a problem.
Well, I find it interesting that the mayor did not cite Times Mirror to the
is the task force still there? Is anyone here still?
Yeah, we're here.
You're having audio problems, Bruce.
Okay. So sorry about that. So I'll repeat what I said. I said I find it interesting that the reason for withholding the information to the requester, the mayor did not cite Times Mirror. But when a complaint was filed to the task force, they then applied Times Mirror. So I find that interesting, that the lack of consistency there.
Well, it sounds like we have the beginnings of a motion, I would say.
Okay, let's. That's what I was just going to ask. Is there a motion?
Member LaHood?
Move it along.
I was going to say, I thought Member LaHood was going to make a motion. Started to.
I lost my window. Sorry. I make a motion that we find a violation for 6726 for improper withholding instead of providing documents with redactions and citation of those redactions.
I'll second that.
Okay.
So, Lila, your motion is to find a violation of 6726 for improper withholding of documents And not providing citations? Is that what you meant?
I guess improper withholding instead of providing documents with, you know what, maybe we just leave it as withholding of documents, because if they had provided them and thought that redactions were required, they could have redacted them and then cited those, but perhaps that is going too far, since the initial point is they improperly withheld the documents.
Okay, so remove and citations of.
Sure.
So I would like to amend the motion to include 6727 based upon the response from the mayor did not cite Times Mirror as their reason, but did so here as part of the complaint. I just find that to be somewhat convenient, and when it should have been presented as their official stance at the time of the withholding. It concerns me that that there's kind of a massaging of which section of law they're going to use as their defense. It's not. The point is it's not based upon complaint that you cite the specific statutory authority in the Public Records Act or elsewhere as part of the complaint process. It's part of, that's why you have done the withholding. You're withholding based upon the disclosure is prohibited by that. And so, I just find it to be kind of not consistent and somewhat weak, a weak defense. So I'd like to amend, I move to amend the motion to add 6727.
B.
Is there a second?
I don't think Lila, do you agree to the amendment before I agree?
I didn't hear that, Fiona.
Oh, I was asking Lila if she agrees to the amendment.
I agree to the amendment, but I thought I heard Member Highland citing a subsection. Was that correct?
Yeah.
Yeah.
All of 6727, or it looks like B in particular is pertinent here.
Actually not. It's either withholding under specific permissive exemption, withholding on the basis that disclosure is prohibited by law, or a withholding on the basis that disclosure would incur civil or criminal liability. I mean, none of those. I mean, they didn't even cite any of that. They claimed it to be for security purposes, and as far as we've done this before, to me it applies. I'm not convinced by their citations that any of this applies. So I see it as a violation of 6727 in whole.
Okay.
And we've done that before.
I accept the amendment.
Seconder agrees.
Okay, so I appreciate the taking the friendly amendment. Any other discussion on the motion, members, before we open it up to public comment?
I think I actually would vote for the initial motion, but I think that the amended motion is I don't know if I can agree to that, because I don't see that there's anything improper about citing to Times Mirror, but that's just my own thought on it.
My point of it is not the point that they use Times Mirror. They can use whatever case law they want, statutory authority or Public Records Act or some other law elsewhere. Okay. The point I'm making is that when the requester made the request and they denied the request, they did not cite Times Mirror to the requester, and that's what the ordinance requires. So then when it comes before the task force as a complaint, then all of a sudden Times Mirror becomes their defense. That seems improper.
Well, I think they did properly state the grounds initially that they thought it's a security issue, and then when it later on they said, yeah, it's a security issue because of Times Mirror, and so that's the case that they're relying on. So I don't know if they needed to put the legal citations in initially when they did say the reason, and that's the reason that was backed up with Times Mirror.
I'm not clear that they use Times Mirror as the security part.
This is Member Wong. I think if you take a look at page 242, you'll see in the response, I think they refer to Government Code 6254F, but they do not cite Times Mirror in their response.
Then that's my point. If you're going to start with something, then you have to follow through. You and not then apply. I don't see the application of now something else later is appropriate. I think it could, because if they didn't cite the California Public Records, let's say they didn't present the California Public Records Act to us here today, okay? And they only cited Times Mirror, then there's complete inconsistency with the process of the reason for withholding. So they start out with the reason being the CPRA, but then they end with the reason being Times Mirror. I'm not following that kind of process. You start, if you're going to cite CPRA, then start with the CPRA, end with the CPRA, or start with Times Mirror, end with Times Mirror. But I don't see how it applies, and I'm kind of in agreement with the petitioner that Times Mirror, to me, Prop 59 does a better job at explaining how the disclosure shall be. In this case, I'm not sure Times Mirror actually applies in the same way. But still, I stand on my original premise for including 6747.
Bruce, FYI, you're cutting out like every 10th word.
Yeah, sorry.
Cheryl, can I briefly?
Go ahead.
Member Schmidt, I know you have a little more background in Times Mirror. Did you say Times Mirror relies on 6255?
Yeah. It relies on two. It has two grounds: 6255 in the deliberative process, and 6255 in security issues. And so, I mean, there are some footnotes to Times Mirror which are also interesting, where it actually does talk about 6254 briefly and says we're not sure if we even need to rely on 6254. So there's nuance to how Times Mirror intersects with this case.
Right, because they only cited because Mr. Heckle's response only cited 6254, and so if times mirror is part of 6255, then I would be inclined to agree with Chair Wolf that it's probably an improper use to bring it now later on because the initial citation was only to 6254. That's why I was asking the background in times mirror.
Okay. Yeah. I mean, I think that ultimately they should. It's my feeling, and again, this is why I would vote for the initial motion, that they can't shield themselves completely by using times mirror. And if you look at the dissent of the times mirror and you read it with the majority, you can see that what they really could do here is just go through and do that redacting process and do the filtering. And if you have security issues, you can deal with it very easily. And I think that the local ordinance does tell them, hey, 6255 is not available here. And I agree with that. But I don't think that means times mirror is completely off the table here. To me, they could say that times mirror and 6254 have some application here, but only to the extent that you can get away with a redacted version as opposed to, no, we're not going to produce anything, which is why they cite times. That's my legal analysis.
Well, then I'll go back to another point I made earlier, was that their justification for withholding the entire record. I mean, in fact, they didn't even use withholding. They testified that exempting the public record because they're claiming that the whole thing is a security risk. You do that, and it creates a precedent for all calendars to be exempt for one reason or another, and then it drives everything into a tailspin. So I absolutely will stand even stronger on 6727 that it was a violation of 6727 because it needed to be a withholding of information. Okay, there's no permissive exemption. Okay. They could have redacted it as they did with the other document that they provided. Frankly, I mean, if I had other questions to ask, it would be things like, what constitutes a future meeting or entry as being public? How far in advance is it? 5 minutes from now, or 5 days from now, 5 weeks, 5 months? Where is that? There's no reasonable scale even go by on that or standard that we can stand on. And at the same time, why is it impossible, or why is it difficult or unreasonable to redact the parts that you want to? I mean, we've gone through other situations that are even more intense. I mean, I come from the same petitioner, but with regards to like metadata and stuff, that can be redacted. Okay, I mean, that even goes even deeper than just a calendar entry. So I'm not necessarily. I can put times mirror that point aside and just stand on this point. Finding in violation of 727.
Chair Wolf, could I make a suggestion? Maybe you could mute your microphone on Teams and just call in to speak on your phone, because we are losing a lot of your testimony. If you need the number, it's on the agenda.
Just to try to briefly respond to that.
Hang on, Dean, let's hang on a second
sure.
till we get Chair Wolf.
Yeah. Although I think he can hear.
He can hear us. It's just that we're having trouble hearing him.
Yeah.
Yeah, and Victor wants him to call in.
It's just a suggestion that may help out.
I mean, to try to respond, I'm not disagreeing that there's a violation here, but it's just my feeling like I don't understand how we should blame the mayor's office for citing Times Mirror. I just, that's the part that I don't go along with. But yeah, there's a violation here. They definitely could have done something with redactions, and they could have. I think they could have done it pretty easily, but they didn't make the effort.
Yeah, I think it's cleaner just to, I think the motion is pretty clean. It doesn't specifically mention that. I think it stands. I think we can probably take a vote on that once Chair Wolf is back. But it's interesting discussion.
Okay, can you hear me?
Yes.
It's still an echo, though. Huge echo.
You want to turn off your
I'm
computer.
just turning. I know. I did.
Computer.
That should be better.
Okay, yeah, you're not.
Okay. So are there any other deliberation on the motion? So the motion on the floor is to find in the violation of 6726 and 6727.
I mean, just to, because we brought up with 6727, is there interest in doing 6724 G, H, and I, or do we feel like that's taking things beyond what we want to consider in this order?
I'm not hearing any response.
Well, I would say that their initial response to Mr. Heckel did not cite 6755. They that kind of came up in the conversation here, so I'm okay with leaving that off.
You're 6255, yeah.
Yeah. So I would leave off that citation. I think we could just stick with the 6726 and 6727.
And 6724 GH and I.
That's what I was commenting on, because I believe those provisions relate to misusing 6755, and Mr. Heckel's initial response to the petitioner did not cite 6255, and so I think we can leave those GH and whatever off.
Okay. All right. Any other comment? Last call. Then we're going to move to public comment. We want to move this meeting along. Okay, let's go for public comment. This is for public comment on not the parties or the witnesses, just members of the public on this motion to find in violation of 6726 and 6727. Is there any public comment? Please unmute yourself by pressing *6. Any public comment?
Stephen Malloy.
Okay, so no public comment. Are we ready for a vote?
I heard Stephen Malloy say he wanted to make a public comment.
Okay.
Yes, thank you.
Go ahead. Okay, Cheryl.
Go ahead.
Yes, members, Stephen Malloy here. I just wanted to make a public comment in support of Anonymous and your work today. I agree with Member Wolf that the shifting narrative of the mayor's office is inappropriate, and therefore under 6726, that withholding as it referenced a citation of laws is appropriate. The mayor's office and their legal counsel is clearly competent enough to understand that shifting narrative is, under the law, actually an indication of wrongdoing. And so Member Wolf, in saying how they're moving the narrative under the law, is appropriate. Thank you.
Any other public comment?
Thanks.
You're welcome. Thank you. Any other public comment? Okay, seeing no public comment, are we ready for a vote?
Could I just comment to clarify something that I think is inaccurate?
Who is that? Who's speaking?
This is Mr. Heckle.
Mr. Heckle, we're just getting ready to vote. I think it's a little inappropriate at this point. Got lots of discussions, been over an hour.
I understand. One sentence, I just want to clarify something.
No, I won't allow it. If you have concerns about the outcome of this, we have a process for reconsideration. I would urge you to use that process like everyone else. I am not going to turn this entire process into now another tailspin because you're bringing up other information. You had your opportunity. I think fair is fair at this point, because if I give it to you, I have to give it to anonymous, and if that starts another hour's conversation, then I would say bring it up under reconsideration if you have new information that might you think that might change the outcome. That's the process. That's our appeals process, essentially. Okay? Thank you.
Yeah, we always do 254 F. That's what we've argued from the beginning.
Okay, please, you know what? That's not fair, man. That's not right. Okay? Please call the roll. Please call the roll.
Thank you.
Okay. Member LaHood? Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to include a motion to find a violation of 6726 for withholding of documents, 6727 for justification of withholding.
Okay, and just so I say it out loud, referring this to compliance and amendments, it automatically gets done under our rules, but I'll just do it as a matter of course. To be that the production of the records is compelled now onto the mayor to produce the records, to disclose them, and to be monitored by the Compliance and Amendments Committee. Okay, let's call next item.
Hang on a second.
Quickly, perhaps we should do another public comment call because we did close public comment before 5 o'clock.
Sure, we can go back to that. Can you please call number 3 again?
Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay. For anyone who has not spoken prior to 5 o'clock, if you have any general public comment for items that are not on our agenda, but within our jurisdiction, please unmute yourself and have the mic. Calling for public comment. General public comment.
Yes, I'm here waiting. Can you hear me?
Next.
Yes, we can hear you.
Go ahead, Mr. Warfield.
Yes, this is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Some of what I'm going to say I've said before, and some of it may have new examples or be new. But I think that, first of all, there's a mess with respect to public participation in meetings and also public access to information in general under COVID. What we've had is a gigantic retraction of government. We have folks no longer in offices. One used to be able to go, for example, to City Hall to visit the office of the supervisor, the clerk of the board, and so on, for 40 hours a week or more, certainly when they were open for 40 hours a week. Impossible now. One used to be able to call and speak to somebody in an office there and other places 40 hours a week and have an expectation that somebody working would be responding either immediately or would give a call back fairly promptly. Completely finished. It's a complete mess with respect to what any standards might be. There are offices that don't give any indication that anything is different than before, but don't get back to you. There are offices that say we're working from home and then say if you have any questions or comments, send us an email. Well, if you don't have email or don't use it for whatever reason, you're out of luck, and there are a lot of people like that. I've cited before the city's own digital equity strategic plan, which had a survey saying over 100,000 people in the city don't have internet access. And of those, of course, the poorest people and the oldest people and the racial divide, as one would imagine, differentially suffer from or experience that kind of an issue. With respect to access of meetings, there's a whole range of problems with that as well. Again, one used to be able to simply go to a meeting. Nowadays, there are some meetings that are held no longer in the city and free access when you have a 669 area code.
30 seconds, sir.
Thank you. Which is on a direct line on a landline, 59 cents a minute plus tax, can be less under other circumstances. Your own, for example, agenda right now doesn't indicate how one speaks. I actually got another meeting that I had a *6 to unmute yourself and a *9 to raise your hand. Your agenda says nothing about how to do that, and it's not unusual. I know you're trying to do a good job, and I appreciate it, but it needs to be
Sir, your time is up.
studied. A meeting needs to be held about this where people can testify. Thank you.
Next speaker, please. Any other public speakers for public comment? Okay, hearing none. Let's call the next item. Public comment is closed. Let's call the next item.
Item number 6, file number 19061, complaint filed by John Hooper against the Office of Economic and Workforce Development for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. Somebody say something?
Good evening.
Hold on a second. Please read the byline, please.
Sure. On January 21, 2020, the task force referred the matter back to the complaint committee and requested that new materials provided to the task force be included in the file for review to determine which documents are applicable to which respondent and provide a recommendation to the task force. On October 20, 2020, the complaint committee determined the records public and referred the matter back to the task force for hearing.
Okay. Before we start with the speakers, I just want to ask the complaint committee if they have anything to add or present.
That's us. I think we asked for certain materials. Most has been provided. I think this was the one that has been with us several times before. If I don't call back here, you guys.
Okay. Thank you.
Anybody else want to say something? I'm
Sure.
sorry. Excuse me for interrupting, Chair Wolf. I just wanted to say that before this hearing, when I was putting together the packets, Mr. Hooper did provide several documents, including an engineering report that I included in the packet that were not available for the complaint committee.
Oh.
And was
Okay.
that something requested?
Are you talking about that were not available for the complaint committee in January or in October?
In October. The one we just had.
Oh.
Oh. Yeah, well, is that, well,
So I guess those were the new materials that were to be included. Yes.
Cheryl, did he receive the engineering report and now
You know what,
we can look at it?
Dean, I don't know how he got it. He said he found it. And he got it and he sent it to me to include in the packet, and so I did. And I'm just saying that this was not made available to the complaint committee at the time of the hearing.
Carol,
Okay.
but it's something that we asked for, because I know we asked him to include the.
He just provided them.
Okay.
I mean, I don't see that we asked for them either, but part of the issue was that there were materials to be reviewed.
Sure, if I recall, it was that Mr. Hooper had requested a variety of documents. The respondent said that they had provided Mr. Hooper everything that they had. Right. Mr. Hooper said that there were additional documents that he wanted, and so we asked him, okay, if you have specific documents, bring them to the full task force and let us know what you believe is still missing, because it was the contention of the respondents that they gave them everything that he had.
That was what Mary Ann Thompson said. Yes, that is correct.
Right. So I'm not. We can maybe let Mr. Hooper talk about the engineering report when we get to that, but I think we need to kind of.
All right, I'm ready. That's fine. That's fine.
Okay. All right. So we're ready to move forward. Okay. Then let's start with the petitioner, Mr. Hooper. You have 5 minutes to make your presentation.
Members of the task force, can you hear me clearly?
Yes.
Yes.
I'm having trouble hearing some of your voices, but let me know if my voice breaks up. I'll speak slowly. So if it helps you, I submitted my written statement, and it's at your pages 964 to 96 if you want to follow along. I'll try to cut to the chase and divide my statement into 2 parts. The requested information that I have not received, and the information that you have received from OEWD, which is incorrect or misleading. So the first item I want to point to concerning information that I have not received, I would ask you to go to the footnotes of my letter to the city attorney, which was dated April 3rd, 2019, and those pertinent footnotes are at your 971-972, at which we find an email between the then Green Benefit District project manager at DPW, Jonathan Goldberg, and a member of the defunct Greater Buena Vista GBD organizing committee, in which the DPW employee states, from instructions from my colleague at OEWD, I have omitted green from Green Benefit District and associated acronyms in the grant proposal, to which the head of the local defunct committee replies, I have changed the language from what I sent to Jonathan Goldberg based on not wanting to identify the project as a green benefit district, since OEWD doesn't seem to fund those. So the first piece of information I want and have never received is, if OEWD does not fund green benefit districts, who did provide the funding? Secondly, I'll ask you to go to the amended appendix to a July 1st contract between OEWD and Francisco Parks Alliance, which you will find at your pagination 1003 to 1011. And you'll notice you go through those deliverables tasks and deliverables that Most of them require invoices or records of payment. I have never received invoices or records of payment. And that goes to the basic question of where is this money coming from and where is it going? So then, again, staying with the updated appendix to the July 1st, 2018 contract, you can look at task 10. You'll find it at your 1005 and 1006, and that pertains to the survey that was done. And you can see for yourselves. I won't read it because I don't have that much time, but there were various items asked for, and then of course the invoice. Our next involved the Mission Dolores Stream Benefit District Management Plan, one of the basic documents. You can find that's passed and deliverable 14, page 1007 in your footnotes. And again,
You have 30 seconds, sir.
Thank you. I won't have time to go through all of this, but I think you can see if you follow through the tasks and deliverables, basically I'm asking for all the information involving what was paid, when it was paid, who provided the money, and who was it paid to. So I'll leave it at that. You have my written statement on the record. You have these appendices that I'm asking you to look at. So I'll stop right there, and I'll take any questions you may have.
Okay, thank you. So I just wanted, I did fail to ask if OEWD is present. Somebody from the Office of Economic Workforce Development representative here. Please unmute yourself, *6. Okay, doesn't seem like that they're present. The other thing is that also it kind of launched into this. This has already been presented to the task force.
Hello.
Hello?
Mary Ann Thompson from OEWD is present.
Oh, okay, great. Okay, so before you speak, since this has already been presented to the task force, and we've already kind of gone through the process of hearing all the testimony, I gave Mr. Hooper an opportunity to make an additional presentation based upon the information that we had requested. I'll give you the same. I'm not going to ask for any witnesses or parties at this time, as reading back, I don't think there was any at the time. So if you would, respondent, please cite your name, and Cheryl, when you're ready, start the clock.
Yeah, I'm ready. You're ready.
Chair Wolf, just a point of order. Chair Wolf?
Yes, go ahead.
Just a point of order. I may have not caught it. Are we hearing items 6 and 7 together? Did I miss that? Or is this just 6? There was some talk. Yeah, there was some talk of it being combined in the past, and that decision would fall to us. Do we make that decision, not make that decision? Looking at the notes.
I don't have any notes. I don't have any motions to do that.
When we just heard complaints, we heard them separately.
Right.
Okay, but in the notes it says that you would leave it to the full task force to consider hearing it together. But anyway, I just wanted to bring that up. But if that's not an issue, then we can move on.
It's not for me. I mean, that if you think that the same issues are applicable for both, I mean, generally it's up to the task force what you folks want to do. If you want to combine it, we can do that, and then just start this process again.
Yeah, it just that the petitioner had originally requested that, and that the subcommittee considered it, and I just didn't see the decision. That's all I was pointing out.
Yeah.
There are two different respondents here. I think it's helpful to hear them, obviously hear both files in the same meeting, but I don't think we want to necessarily combine the two files since there are two distinct respondents who may have very different reasons for, delivering or not delivering the record. So
I just want to acknowledge that the petitioner had asked, and that's that we
okay. Generally, just as a process point, if it was different issues, but the same complainant and the same respondent, we might want to combine them if it was on the same subject. But if it was, different violations, this one I think it's too distinct in my read of it. So unless somebody has a very strong feeling about it and wants to combine them, make the motion. Okay, so let's move on. Okay, OEWD, you have 5 minutes.
Yeah, can you hear me?
Yes, go ahead.
Thank you. For the record, my name is Mary Ann Thompson, the Office of Economic and Workforce Development. Also, for the record, I'd like to state that I have been working at the COVID Command Center since 7:30 this morning, and this now makes this a almost 12-hour day. So what would be greatly appreciated is in the future, if we could be just a little bit more organized, that would be awesome and amazing. OEWD stands to the record that we have provided Mr. Hooper, Mr. Tomasevich, Mr. Sullivan, all of the documents that have been requested by them, and there are no more documents to be provided. I point out to Mr. Hooper and to you all that the first item that Mr. Hooper is reporting to is an email between Jonathan to another employee. Jonathan does not work for OEWD, so I would not have access to that email. We have provided Mr. Hooper with his survey. It was done by SurveyMonkey. We gave him the contents in a spreadsheet. I don't know how else to give him the contents to the survey, except to say that it just lands itself in a spreadsheet. We provided him with all of the invoices and all of the records. I'd like to point out that this contract started with Build, then moved over to Parks Alliance. Build is no longer in existence. It went from 13 deliverables down to 8 deliverables. We provided Mr. Hooper with all of those items, and I don't know what else to provide you with to get myself off of this little wheel that we seem to be stuck on, and these 12-hour days that I seem to be stuck with, especially working at the COVID Command Center. I'm trying to keep you and everyone else safe. That's my response.
Okay, are you finished?
Oh, I'm finished.
Yes, good. Okay, thank you. Okay, so members, the item is back to you.
This is Member Wong.
Go ahead.
I was wondering if someone who was on the task force when this was first heard could kind of go over a little bit of what happened at that point in time, and then I know it went back to the complaints committee. So I'm just curious if there's like specific information that was provided here as requested.
I can give you a little background since we just reviewed it in complaints again. Essentially, Mr. Hooper is looking for information regarding this contract. I think parts of it may be with this respondent. Parts of it may also be with Public Works. Both departments supplied Mr. Hooper with a variety of documents. What they contend was everything they had that's responsive. Mr. Hooper contends that there are additional documents that are out there that still need to be turned over. Essentially, both respondents and are saying we don't have anything more. We give literally everything we have, and that's kind of where we are. We've kind of gone back and forth and back and forth, and so that's why the complaints committee asked Mr. Hooper to come up with a very specific list of documents that he believes are still outstanding, that he believes are still existing, that he has not received, so that we could, finally put an end to this back and forth and finish this case off. That's kind of where we're at. Looking at what Mr. Hooper may still believe is outstanding, because this is the same response that we keep getting back from the respondent, that they've given him everything they have. Does that help?
Yeah, that's great. Thank you.
Okay, sure.
If I could just flesh out one of those points, which is that Mr. Hooper has given us a good legal citation, which is the community legal, or community youth athletic center, which puts a certain level of responsibility on the agency to contact, when they contract out, to contact them when they get a public records request, to contact the contractor and say, hey, we got a request and we need certain documents from you. Now, it's not a universal obligation, but I think it does come into play in this situation. And that's something we did talk about at the complaint committee.
I'd also like to address that at the complaint committee. OEWD did reach out to Parks Alliance, and we asked them if they had any further documents, any further emails, and they said no. So we did address that particular issue, and we did close out that particular issue.
So, Ms. Thompson, so one of the things that I think was asked is if you knew of any other agency besides that has had contact with the particular issue in order for Mr. Hooper to obtain the records he's looking for.
So again, I just want to go back, and I'm really sorry to be terse with you all, but I just really want to explain the situation to you. I have been working since 7:30 this morning at the COVID Command Center, working on COVID and keeping people safe. And now here I am at 6:41 in the evening responding to Mr. Hooper again for the 6th time this year and last year. We have provided Mr. Hooper with all of the emails, all of the responsive documents. We've connected him to any department that we thought had any piece of this file, and he has had access to all of that. To include, and to my credit, I would really like to be acknowledged for this, when I found additional documents that were not in my control, but in fact in control of our contracting office, I provided them to Mr. Hooper and Cheryl and everyone else to show that OEWD goes above and beyond when it comes to transparency. We have provided Mr. Hooper with every document available. We've even connected him to other departments that may or may not, like a previous supervisor who may or may not have funded a green benefits district. We provide him all of those things, and we have satisfied all of his requests. We have satisfied Mr. Hooper's request, Mr. Tomasovich's request, Mr. Sullivan's request. Everyone who provided us and asked us for all those documents, we provided them. I have nothing else to give you but my gray hair and my blood.
Okay, thank you. Mr. Hooper, what now do you feel you're still missing?
Thank you, members of the task force. If you'll look at my written statement submitted for today's hearing, pages 964 to 966, you go down the first page to 1A, 1B, 1C, D, E, F, G, H. 1, 8 through 8 enumerate the documents which are specific to reference contract between OEWD and Parks Alliance, which I have never received. I would also say, Mr. Chairman, that I have asked, I think, the same specificity for the same documents, number of other occasions. And you can look at my prior requests at your pages 1012, 1013, 1015, and then 1417 and 1418. So it shouldn't come as any surprise to anybody that the mere fact that you were told repeatedly that Mr. Hooper loses documents and Mr. Hooper has received everything doesn't make it so.
Okay, so let me.
Excuse me. At the complaints committee, you were also informed that there was no engineer's report involved in the contract. That is completely incorrect information, which was provided to you by the custodian. So, you know, you can decide where to go from here, but you're not getting correct information.
Okay, Mr. Hooper, so I'm looking at page 964. I see 1A. Did you receive, let's go through it one by one, and let's figure out what you have and what you don't have now. Okay, because we just got these new documents. The complaint committee was supposed to have received those, and it puts a little extra, also puts an extra burden on the task force in a short period of time to have to go through a considerable amount of more documents. So just to be clear, so we can put this to rest, I'd like to start with 1A. Okay,
right.
Can you tell us?
Yes, Mr. Chairman, if this is the chairman speaking, thanks for that. I will say, though, just to correct your impression, that the documents that we will now be referring to, which is the tasks and deliverables for Project B, or for Area B, Dolores Park neighborhood, I submitted for the record on January 21st, 2020. So they're not new. Okay, so before my 5 minutes expired, I think I explained to you why I want more information about funding for the Green Benefit District. And going on to 1B, if you just look through the 31 tasks and deliverables, you'll see that almost all of them ask for invoices or other records of payment. I've never received any invoices or records of payment. Then if you go to 1C.
So wait a minute. Like I asked, hold on. I need to take this one item at a time. So with 1A, the funding for the Green Benefits District, did you receive any information with regards to the funding?
No, the question arose because in a dialogue between the then DPW Green Benefits District manager and a defunct attempt to form a Green Benefits District in the Haight-Ashbury, it was clearly stated that OEWD does not fund Green Benefit District. So they changed the name of that to omit the word green so that it would therefore somehow qualify this thing. The question that arises is, if OEWD doesn't fund Green Benefit Districts, who does fund them? We've never gotten to the bottom of that.
Okay, thank you. So in 1B, okay, so 1B, did you receive any invoices, any of these deliverables?
Well, I want to separate the question into two parts. I have not received any invoices or records of payment. Those are the things that really give you the trail of breadcrumbs. Some of the deliverables I have received, not necessarily through Public Records Act requests, but actually more generally through the good efforts of citizen activists. For example, you were told by Marianne Thompson on October 20th at the Night Committee that there is no engineer's report. Well, of course there was an engineer's report. They couldn't have launched their year-long petition drive unless the engineer's report had been.
Okay, but you're now, hold on, Mr. Hooper, please. I'm trying to go in order here. You're now jumping to 1E, okay?
Okay.
I'd like to stay on 1B so we can get through this. You cite that there were that you haven't received any invoices or records of payment cited as deliverables in 31 in the 31 deliverables outlined in the appendix. Okay, is that still the case?
That would cover 1B, yes.
Okay. In 1C, Parks Alliance interactions with Mission Dolores Green Benefits District Committee. I have not received Parks Alliance recommendations and suggestions. Have you received any of those?
Negative.
Okay. 1D, the Mission Dolores GBD management plan. Have you received any information regarding that?
I have a copy of the management plan, which was at one time, although now deleted on a website that the city paid.
It's just a yes and no question, please. Just a yes and no question. You have not. You have or have not?
I have received the management plan. I have not received the other information that I asked for in 1D. The approval letter from the city's team, the approval letter from the city attorney, the invoices, and the management plan in its prior draft form. Those things I have not, that is negative, received. Okay.
Let me just stop there for a moment. For all these items, OEWD is stating that they don't have any more responsive records with regards to these. Okay, what makes you think that they have records? Do you have any evidence? Do you have any kind of knowledge that they might still have records? And if not, then the question then becomes: did they tell you or us where else that we could find those records?
Well, to take the latter part of your question first, it seems fairly clear that if the records do not reside at OEWD, they must reside somewhere in the other obvious places that they would reside with the contractor, Parks Alliance. The reason I think they exist is the plain reading of the appendix that we've been going through.
Okay, hold on a second. I need to ask OEWD a question. So, Ms. Thompson, for the Green Benefits District, who is the agency that contracted with Parks Alliance?
So that's here, OEWD to contract with Parks Alliance. Did you like me to respond to 1A, 1B, 1C, and 1D?
No. We'll get to that in a moment, but I just want to ask this quick question. For Parks Alliance, since it's mentioned in many places here, who is the contracting agency?
OEWD.
Okay. So now, were they contracted by the city to provide a service that the city would normally provide, or are they providing some external, like what they usually do, and providing after school or extracurricular activities?
I'm sorry, can you clarify that question?
So I'm trying to discern whether they are a 12L nonprofit. If, for instance, Parks Alliance provides services to the Rec and Park Department with regards to providing sports and athletic activities. Okay, if the member of the public had any questions about those activities, they would have to ask Rec and Park for the information, because they're the contracting agency, and Rec and Park would be receiving certain or all information regarding those activities, and not any others regarding other things that Parks Alliance may or may not do. Is that clear?
Not really. I guess what I'm going to explain to you is that OEWD does not have, nor does Public Works have the employees or the capacity to do community outreach engagement for green benefit districts or civic center commons or any of those things. And so we frequently contract with them to do the work that we do not have capacity to do.
Okay. So great. So they were providing, you're basically hiring them to provide you services that you don't have the capacity to do.
Correct.
Okay, great. So, okay, that's great. So let me just make a quick note of that. Okay, now, thank you. Now we can, let's start with, I'll stay with you, Ms. Thompson. So for 1A, for the funding of the Green Benefits District, have you provided the information? Essentially he was requesting all sources and expenditures of funds with regards to the funding. Was the funding provided by OEWD?
So I want to refresh everyone's memories because I know this has been a long time in the making. I want to explain this. There are a number of green benefit districts from Mission Dolores to Buena Vista to a number of them. So I want to paint this picture of the city as a whole, and OEWD frequently, in particular Mission Dolores, the then supervisor gave OEWD an ad back and said, we would like you to explore, the community would like you to explore the formation of a green benefits district in order to support Mission Dolores. That is one source of funding. Another source of funding may in fact be an ad back from Public Works, who says, we would like you to explore a green benefits district at Buena Vista Park. So the funding source is never OEWD, it's never us. We do not spend our money on these particular types of explorations. They are often ad backs from a supervisor, from a department, something that the community has gone to the supervisor, the department, and requested. So the funding source is never OEWD. It is always an ad back from another person or another department.
But do you have knowledge of where those sources are coming from in order to be able to pay Parks Alliance, let's say?
Correct. And we have provided all of that information to Mr. Hooper, to Mr. Sullivan.
Okay. Mr. Sullivan, please, Ms. Thompson, we're only dealing with Mr. Hooper. We're not dealing with Mr. Sullivan or anybody else.
That's okay.
I'm sorry, Ms. Thompson. In this case, it's just Mr. Hooper. So we're only dealing with Mr. Hooper. Mr. Hooper, let me ask you now, based upon 1A, have you received that information from OEWD? Any information with regarding sources and expenditures?
Negative.
You haven't. Okay.
I have not received any of the information that was described to you.
Okay, so here's what's going to happen. So, Ms. Thompson, have you provided that information for the record here today?
Yes, we provided every document that we have provided, Mr. Hooper, we have provided to Cheryl as well.
Okay, are you able to point to us this particular item?
No, because I am not at my computer. I am home, and this is just above and beyond. But yes, in fact, we have provided Mr. Hooper and Cheryl every single one of those documents.
Okay, I hear you, but there's a limit to what is our responsibility to figure out what records are supposed to be from where. If we have a dispute, we're going to ask the parties we're not going to be the ones to solve the dispute per se. We're going to ask the parties for the evidence. Mr. Hooper says he didn't get it. You said you provided it. So, you know, somebody's got to produce it. That's what we're here for. If you produce it, and no, it's not Cheryl's job to do that.
I provided it to her for all of these supporting documents. I provided her with every email that I have replied to Mr. Hooper. I have CC'd Cheryl on, and she, in fact, has all of the documents. And if in the future you'd like them in your package, I'm happy to send them again. But I'm just simply saying that when I CC Cheryl on an email, it is my understanding that I am also including you in the totality of those documents.
Yes, I understand that, but it's not up to us to be able to discern what is and what isn't the applicable document. If there are 1,000 documents, it's not us. This is like court. You have to tell us where they are, which particular documents they are. We're not going to go. We're all volunteers. We don't get paid for any of this.
Neither do I, just so we're clear.
Well, frankly, I'm
a salaried employee, and at this point, I am not being paid to be here. But what I am here to do is to provide to you an understanding of the level of transparency that OEWD has gone to provide Mr. Hooper, to provide Mr. Sullivan, to provide Mr. Tomasevich, all of the documents. And we've done it consistently over the last 2 years. And yet, it seems like every time we get here, it's like Groundhog's Day. No one can remember why we're here. No one can remember who got what documents. At a certain point, there just has to be a level of common sense that just doesn't seem to exist. And if you're going to reference court, I'm going to bring this up to you. Just remember this. In a court of law, when someone says to you, with all due respect, they don't mean with all due respect. So, with all due respect to Mr. Hooper, I am exhausted. I have provided him with every document he could possibly ask for. I have gone above and beyond. I provided him with documents after his case was closed out, after I had closed out all his reports. I have done everything I can, and there's nothing more that I can provide him with. And I'd like to point out that all of these contracts have been closed out and sunset over a year ago.
That's of no consequence. The records have to be retained. And if people request historical documents, they must be produced. That's the way the law is written.
Policy is 2 years. Our record retention policy is 2 years.
And we provided
Mr. Hooper with our record retention policy is 2 years. I will have you go look at our website. And we provided Mr. Hooper with every document. With regard to item 1,
let me acknowledge that you have provided a considerable amount of documentation with regards to this request. Okay, and that's appreciated because a lot of city departments don't do it to that extent. Okay, but I will say also that you're welcome. I will say also that not necessarily you, but that we do get from time to time when there is a big data dump of information that is provided to the requester that doesn't have one iota of information that they originally asked for. They just dump, thousands of pages of them to sift through and don't provide them with any responsive records. So I'm not saying you're doing that. I'm not saying you're doing that.
I agree with you 100%. I agree with you. And I want to speak to that really quickly because one of the things that I have done, and you can look at all of my documents, when someone makes a sunshine request to OEWD, we work with them to narrow down the scope so that we don't give them a data dump, so that I don't send them 2,000 responsive documents that they have to piece together. I've met with Mr. Hooper. I've met with Mr. Sullivan. I have met with everyone personally, one-on-one, and said, I want to provide you the documents that will support you, but you have to be specific. And here's how we're going to get there. And I have done that with every single one of them, and it doesn't seem to satisfy this insatiable need to figure out what they don't have. We have, I mean, our office went above and beyond. Long
Okay,
after that contract
I get that.
was out.
I get that, but it's the public's right. These are the public's records. They have a right to request them because they don't know what's available. You know, they're basically in a level of the unknown. So they have a right to ask, you know. So I appreciate that.
You know, I also want to point something out to you. One of the things that OEWD does that goes above and beyond what is required in each individual department is we also make available the person who's responsible for those documents. And if we say, if you'd like to speak to Mary Ann, here's her contact information. She's happy to speak with you. We go above and beyond because no other department works harder to create transparency than our department. But at a certain point, like I can't give you any more. I can't give you what I don't have.
Can you say it again?
Okay, I hear you, and I hear your exasperation. I'm going to give you a break for a moment. Okay, Mr. Hooper, let me just ask you. I mean, if all the records had been provided to you, had been also provided to us, have you found any, like let's say for 1A?
Okay.
Yeah. There's a lot of background noise. I'm sorry, there's a lot of background noise.
Is there another conversation going on, Mr. Chairman? I'm having a hard time hearing you.
Yeah, so am I.
Sure. Victor, can you mute yourself?
I think he did.
You did. Okay, so Mr. Hooper,
I'm right.
let me ask you, I'm running this meeting, let me ask you, in 1A for funding for Green Benefits District, have you looked through the record that we have that was compiled by us to see if any of those records that you didn't get were produced?
Well, Mr.
That's part of our job.
I'm sorry. I'm still feeling that someone else is speaking at the same time. To try to answer your question, Mr. Chairman, and I think you raised an excellent point when you asked Ms. Thompson if she could point to the records in your file which responded to my request. And I've gone through the SOTF files fairly rigorously, and there's not actually that much. Certainly, the dump I got from OEWD in one day of 600 documents is not part of your record. So I think you asked exactly the right question when you said, can OEWD point its finger at how it responded? I would say that dumping 600 documents in 44 emails to me a month after I asked for them a year and a half ago is kind of like what you were describing. It's a data dump. It's largely irrelevant. So
okay,
I think simple. Well, if I may, just a simple answer to the dilemma might be to say to OEWD, provide us, that is you, SOTF, with the same information that they allege to have provided to me. And then that would be, then even though it would be cumbersome, at least we'd all be working from the same information instead of you're hearing that we've gone above and beyond our duty. And incidentally, Ms. Thompson has never met with me. She just said she had. I've never met with Ms. Thompson.
I would like to remind Mr. Hooper of my experience with him in the hallway.
Ms. Thompson met me in the hallway.
I am not going to have, no, we are not going to do this. Not in this venue. We are not going to do this here. The task force has a particular job to do. This is not an open arena for you folks to debate with each other. It's just not going to happen. Members, this is getting very now kind of enormous and complex. There's a lot of documents here. There is still some claims that documents have not been received, and there are claims from the other party that documents were provided, but we don't know which ones they are because of the conditions that the respondent is in right now. So I frankly am of the mind to send this back to committee and have committee to go through whatever is not has not been received that Mr. Hooper thinks or feels or knows that he hasn't received, and to work through those documents with the OEWD to find them. Because if they say that they produced them and that they've been delivered to our office and they're in the record, then there's got to be some way to bring this to a close. And I don't, unless you have some other idea, that's what I'm suggesting at this point.
Do any of the rest of us get to ask questions of the witness?
Absolutely.
Okay. Thank you.
No problem. Go ahead. Member Schmidt.
Mr. Hooper, when did you receive a copy of the engineer's report?
I received a copy of the engineer's report from another concerned San Franciscan who had the presence of mind to take a screenshot of it off the Mission Dolores DVD website, knowing that information then disappears and is irretrievable. I think
okay.
I received it a few weeks ago. I asked for it among my fellow concerned citizens because at the October committee meeting, October 20th Complaints Committee, the committee was informed that there was no engineer's report for contract between OEWD and Parks Alliance, and that is completely inaccurate information.
So by looking at what you received, you determined that it's incorrect that there was no engineering report, correct?
Well, let me put it.
There was an engineer's report, right?
You were told there was no engineer's report.
Yeah, and now you know there was one, right?
That is correct. There was one, and
okay.
It's the only legal document that's required in the formation of benefit districts so that the city can proceed with a petition drive. So it's a critical document, and for you to be told that it wasn't required is simply inaccurate.
Okay, and I know you got it from another source, but do you feel like you have now been able to see what would be the complete engineer's report, or are there other parts of it that you still need to see?
It's not the engineer's report I need to see. I saw it a year ago. I just didn't happen to take a screenshot of it before it disappeared. What I have not seen is who paid for it. Did Parks Alliance pay for it?
Yeah.
Where did the money come from? Did it come from OEWD? Ms. Thompson tells you that OEWD doesn't fund anything. So where's the money coming from?
And Ms. Thompson, I'll ask you as to that question of the money. Does your office have any documentation of those kind of payments?
Yes. So just to be clear, I did send those payments. So again, this is very, very difficult to explain.
Did you send those invoices to Mr. Hooper?
So, yes, but I do need to explain some. No.
Did you withhold anything?
No, we did not. But some of those green benefit districts sunsetted before the deliverables were provided, so there are no invoices for work that was never completed.
Okay, so how many invoices would fit the terminology in Mr. Hooper's request? A number or an estimate?
I would not be able to give you that number off the top of my head because, again, Sunshine Ordinance doesn't require me to describe every document provided or a narrative to explain all the documents. It only requires the production of the records. I would not know off the top of my head how many invoices there are.
Can you give me an estimate of how many pages you produced in response to his request for invoices?
To Mr. For invoices, that I would not know, but I do know that I provided him with close to 1,000 documents.
1,000 documents. Okay. Mr. Hooper, how many pages did you receive in your response to your request for invoices?
I did not separate my request for my Public Records Act request of February 2019. I included a request for invoices with lots of other information that I hope to obtain. I didn't separate out a request for invoices from a lot of other information I wanted. So I can't really answer the question exactly, but I can tell you that after a long delay, in one day, I'm going to say maybe March or April of 2019, I received 44 emails from OEWD in one day. Each of which had a multitude of attachments entitled redacted documents. And I think if you added up the 44 emails and the number of attachments, I would say I received, I can't tell you pages, but probably over 600 pieces of information, much of which was completely irrelevant.
Okay. When you say I have not received any invoices or records of payment, that means zero? You haven't gotten anything?
No, I'm trying to make that clear that one of the key...
Did you ask for
issues,
those?
Well, you can go back to my February 11th letter, my original PRA request of February 11th, 2019, and it's pretty clear. There's 9 questions there. Of course, the time, as the chair mentioned, one also often doesn't really know what is there, so the questions are somewhat general, but they certainly would ask for that. And then I renewed that request in May of 2019.
Okay. I have no further questions right now.
Mr. Chair, if I may.
Yes, go ahead, Member Hinsey.
This is actually, I guess, directed at you, Mr. Chair. I'm currently, sorry, with your inclination to send this back to committee. Unfortunately for the party, the complaint committee has been doing it. I wonder if it would be more of a CAC issue now. We can get to that when we make the motion, but I just want to put that in the back of your head.
Well, I think at this point, the question is whether all the documents that have been produced are responsive or not. I mean, this is we haven't had a motion on this yet. There's been no order of determination. We sent this back to committee because of the vast amount of documentation that was here to be able to figure out which documents exactly were still not provided. And if the OEWD did provide them and was able to prove it, then then it helps us figure out whether there was a violation or not a violation. There could have been a snafu in the delivery, or it could be just it was not there during a large delivery. It was overlooked for some reason. Who knows? But at this point, this right now in the middle of a full task force meeting is not the appropriate place to be now going digging around to figure all this out. I mean, frankly, it is a responsibility of the respondent to provide the record that is being requested, even if it is 10,000 records. If the requester has gone through 10,000 records and says it's not here, it still is not here, and the respondent says it is, I sent it, then it's up to the respondent to be able to say, here it is, and here's when I sent it to you. And then that is that. Then there's no violation at that point. That's what we're here for. Okay? And if there is unresponsive record, I mean, we all know what our job here is. So I think it really is incumbent upon the committee, the complaint committee, to be to assure that the record is the file is got all the records that was needed. I think it'll go if we find a violation that the records aren't there, and we compel OEWD to produce the records, then the CAC will have the job of monitoring it at that point. And I think that's where that's our appropriate process.
I have no problem with sending it back to committee, but when we did have it in committee, I felt that we had found a violation in terms of the engineer's report. And in terms of other documents, one side says they're out there and one side says they're not. And so I'm not sure what more we could have done, but there was, to me, a pretty clear violation, at least with regard to this engineer's report. So I don't know if we need to get a full list of documents in committee. We could try. So sure, either way.
Mr. Chairman, this is John Hooper. May I say a word?
Sure. If it's to the point, to this point.
I believe it is. And it's your idea. If you look at the record that has been submitted to the Sunshine Ordinance Task Force, there's very little information submitted by OEWD. If OEWD were to submit to you those same 44 emails and multitudes of attachments that they sent to me, it might be cumbersome, but we can just sort it out. It's not in your record, in other words.
Well, we don't know that it's not in our record unless somebody sits and reads through every single piece.
Can I just speak to that quickly, Bruce?
One moment.
One
moment. One person speaking at a time. One moment. Let me facilitate here, please.
Who has the
Mr. Hooper, I would just say that it is not incumbent. It's incumbent upon the task force to understand what the case is. It's incumbent upon the parties to be able to produce what it is and what it isn't that they got or didn't get at that point. We are not going to do your job. Any party. That's not our purpose here. You present your cases, and then however the chips may fall, that's the way it is. So, Ms. Thompson, your turn. Go ahead.
Yeah, I would just like to point out to the members of the task force that the Mission Dolores Green Benefit District Management Plan is actually page 576 of the packet. So I hope you can see that I have in fact provided Mr. Hooper with all of the documents, and if he would like me to sit down and go over them one page at a time, I'm happy to do that in 2022.
In when you said?
2022. I have been deployed to the COVID Command Center until July of 2021. And so I'm happy to provide that content to Mr. Hooper in 2021 post-July or 2022.
Okay. Okay, members, I'm going to stop talking now. Do anybody have any other comments?
Just to follow up on Member Schmidt, Ms. Thompson, does your department had a copy of that engineer's report? Or if you did not have a copy, do you know which department did have a copy of it?
It would not. If I did not provide it to Mr. Hooper, it does not sit with my department.
Okay. I'm thinking that that it might be a good idea to send this back to committee, but at the same token, I think it needs to have some type of structure beforehand. I think Mr. Hooper needs to come up with a specific written list of what he feels he still needs. I think that written list potentially could then go to Ms. Thompson, that she could say, respond accordingly. Because I see what seemed to happen when we got into committee, and I don't want to have happen again, is that Mr. Hooper makes these very broad remarks about what he needs, and Ms. Thompson will say, well, I gave him 1,000 documents, and then basically throw it in our lap to try to sort out what matches with what. And we can't go through 1,000 documents in committee and try to fit this through. So I think there needs to be some form of cooperation between the two of them, even if it's in a written back and forth, before it gets to committee.
Okay. I'm all for it, and I would be happy to do this July of 2021.
Mr. Chairman, may I say a word?
Yes, Mr. Hooper.
Thank you. The specific list that your colleague just asked for is provided in my written statement, which you have before you, and the one that we were starting to go through. So I think that's a good idea. And if Ms. Thompson were to follow my 1A through 1H, those, I don't see how one could be more specific. Those are very specific requests for documents. And I would just state for the record that I have also submitted very specific requests for documents which you have in your record. So I think that's a reasonable way to proceed, but I don't think the shoe is necessarily on my foot at this point. If you don't that list I submitted is specific enough, I'm happy to refine it based on your guidance. But I think you've got what you need from me. What I'm missing in very specific forms and why I know it exists.
Yeah, I do think that list is very much along the lines of what we talked about in the complaint committee. And so my recommendation is what I'm thinking is that Ms. Thompson or someone from that department, if she's deployed at the COVID center or what have you, but this can't obviously wait until the end of 2021. We need to get this resolved. So someone needs to go through needs to go through Mr. Hooper's list, point him to where those documents are. Then we can look at this in the complaint committee and verify, yep, it's been taken care of, and then finally put an end to it.
And
that would be
Mr. Hooper, hold on. If Mr. Hooper, you continue to say that you know that they have it, okay? And it's hard for us to be able to go on that without any kind of evidence that they do. Sounds like a supposition in a way. And even though we know we're trying to put the burden on the respondent to produce it, but if they say they don't have it, then they don't have it. But they're supposed to at least know who does, and help point you in the right direction as to where you might be able to find it, because it has to exist somewhere. And all this whole kind of project, involves a lot of different agencies. So, go ahead, Mr. Hooper.
Thank you. Well, Mr. Chairman and members of the task force, you can follow the 31 tasks and deliverables, and it's easily ascertainable that the Mission Dolores Green Benefit District, like most of these city-funded efforts, fell apart for lack of public support. But at the point it fell apart, they had completed through task and deliverable 16. So, in other words, we know they did a management plan. We know they finalized and presumably paid for an engineer's report. We know they launched the petition drive, and then they weren't able to get the requisite number of property owners to sign on after a year and a half of bludgeoning them about the head and shoulders. So they gave up the whole thing, but that's not hypothetical on my part. That is a fact, that's how far the city got, using Parks Alliance as its foot soldier to try to convince people in that neighborhood to assess themselves to pay for extra services. And at the point they failed, they had completed a great number of those tasks. So that's easily ascertainable. That's factual record, not some member of the public thinking it might have happened. It's right before our very eyes. So I think you can be assured that when I say I know it exists and that's why.
But that's fine, but it may not be with that department.
Well, this is the shell game, and we're going to get to that.
I'm sorry. I hear you, but you know that our city is made up of it's complex, and everybody has a little hand in different places. So yes, it does feel like a shell game. I hear you, but generally it's a matter of who's responsible for what pot of money or for what services and contracts. And just because one department doesn't have it doesn't mean they don't know who does. They probably do or can find out. And the way the ordinance is written, they're supposed to help. To help you on your way to get your request met. So that's what I don't want to continue down this road if they keep saying that part of this process was not in our department and we don't know which one is, then that's really the kind of the end for that particular question.
Well, Mr. Chairman and members of the task force, I think the simplest solution would be for you, the task force, to take up the suggestion of your fellow member and ask to direct that OEWD respond to my questions on my written statement 1A through 1H. That would move the process ahead very productively.
Okay, fine. Let's stop there. Vice Chair Yankee, would you like to present how this process would go or should go?
Sure. I would move that we refer this back to the Complaints Committee, but before the Complaints Committee hears it, that the respondent respond to Mr. Hooper's list of documents that he's still searching for, 1A through 1H, prior to that meeting.
This is Member Wong. Can I make a suggestion related to that list? Yep. I think so. When I look through the list, it seems like there are a lot of references to different pages and appendices, which I personally find difficult to follow. I might recommend to Mr. Hooper that he make a very clear, spelled out list of every single document, and then have the references on top of that. Because currently, I think, for example, if we see invoices or records for item 1B, we see invoices or records of payments cited as deliverables and the 31 deliverables outlined in this index. I would love to see an itemized list of those 31 deliverables.
Yeah, actually, I think that's a good point. This is something in less paragraph form and more bullet point by bullet point. So, all right, so I'll amend the motion to have Mr. Hooper develop a bullet point or itemized list of documents that he is still requesting. Send that to our administrator, who will forward it to the respondent for completion. I don't know if we want to set a time limit for this, but that once that the respondent responds to that itemized list, then it can go to the complaint committee to review. But only at that point. I don't think we can throw this on the complaint committee again to try to weed through thousands of documents. That's just unproductive.
Okay, that's a motion. A motion, Vice Chair.
Sure, that's a motion. Cheryl, did you get all that?
Let's get a second first to make sure it's official.
This is Member Wong. I will second the motion.
Okay, great. Now, Cheryl, did you get the whole motion?
He amended the motion. Let's see. to have Mr. Cooper develop a bullet point list of records to send to the respondent. Once the respondent responds, then it can be scheduled before complaint committee.
Yes. And did we want to set a time limit on that?
We don't want to say a month. Let's give them some time. Mary Ann, you know.
Right. I just don't want to see this being pushed out till the end of, out to 2022. I don't think that's reasonable. I think.
No, that's not reasonable.
I think this needs to be. What do you guys think? Maybe within the next 90 days? Can we,
like March? We want to think about the March complaint committee.
Yeah, maybe the March complaint committee.
Members of the task force, you know what? I would say to you this. I've given Mr. Cooper every document we have. I don't believe that. Why is this finding in violation?
Okay, but we're in the middle of a motion right here.
Point of order, Mr. Chairman, please mute the speaker.
I think we should expedite this and make it easier on all of us. Just go ahead. Finding in violation.
I think the chair is frozen. We need the vice chair to take over.
Ms. Thompson, this is not your time to speak. We're not having this right now.
Right. So we're
members. So
there's a motion on the floor. We're going to continue with our process. Members, are there any other discussion on the motion? Okay, let's take public comment on the motion.
Yes,
any
please.
Public comment on the motion? This is not the parties. This is just the public.
Yes, public comment.
Hang on.
Go
I'd
ahead.
like to make a comment.
Okay.
Hello.
Hi, hello. Can you hear me?
Yes, go ahead.
Yes. So I've been listening to this very intently. Yeah, my name is Rick Carell. I live on Cumberland Street in the proposed Mission Dolores Green Benefit District boundary. So I'm very interested in this because this would raise my property tax. The previous public record request that we made identified that Mohammed Nuru is the person who initiated the entire Green Benefit District process. We also identified that DPW street cleaning grants were repurposed to fund website development, engineering reports, which we talked about, and other Green Benefit District organizing activities, which were performed by the nonprofit SF Parks Alliance. A report from the San Francisco Controller's Office alleges that the SF Parks Alliance was used to funnel money from businesses seeking contract within the city's Public Works Department to Nuru and his staff as part of a corrupt pay operation. The GBD and related commercial benefit district process establishes an ecosystem of favored private contractors and creates opportunities for similar kickback schemes. For example, a summary of CBD services from the OEWD website shows 2 vendors share 9 of 12 street cleaning contracts. Without the ability of private citizens like Mr. Hooper to get discovery from entities like SF Parks Alliance, this type of graft and fraud will only increase. And so I was there with some of these interactions between Ms. Thompson and Mr. Hooper. I was there for that, which were very cursory. She has not been forthcoming. You know, I have to question whether she's involved in covering up some of this stuff. This goes right back to all this pay-to-play stuff that's been going on, and this dragging it out. Like, we can't get the records until 2022. Like, what's that all about? This is just covering up graft is what this is doing. So I'll end my comment right there. Thank you.
Thank you. Next speaker.
Hang on, I didn't get the name of that person. Who was your name, sir? Sir? The gentleman who just spoke? Hello?
Carell. C-A-R-E-L-L. Yes.
C-A-R...
C-A-R-E-L-L. 1 or 2 L's. I think Ms. Thompson should be ashamed of herself.
Okay.
Hang on.
Mr. Carell, you finished your comment. Thank you very much.
May I speak?
Oh, hang on.
Let me know when I can begin.
Go ahead, Anonymous.
Hi, this is Anonymous once again. And I have to say, I was quite sympathetic to the respondent's representative until she said that
she's a salaried employee and it's not part of her, she doesn't get paid to do this. And I don't know if she gets paid extra to do this, but it is according to the Sunshine Ordinance, it is the responsibility of every single public employee to follow the Sunshine Ordinance. That includes hearings before this task force. And that's just a separate thing I wanted to say. And I think you may be able to provide more guidance to kind of figuring this out. First of all, it is the case the respondent has the sole burden of proof to prove that a particular record was provided to the requester. And if they can't prove it, they can't give you a page number, they can't tell you where it is. And as long as it's not just like a clerical error, then you have to find against them eventually whenever you do this. So I would say instead of just a bulleted point list, I'd also ask that you say for each of them, the respondent should say, here's the page number, or we have no responsive records, or we withheld them, the normal response they should give to each of these requests. That's how it should be. And they should have to do that. They should not wait till July 2021. It's the responsibility of the respondent here today, their manager, not them personally, their manager, or technically under the law, their department head, to have sufficient resources to respond to these requests and these complaints. And that's not a personal, I see the frustration in this one person, but she should tell this to her boss, her department head, and the department head should find enough resources to lawfully respond to these requests and these complaints. Thank you very much.
Thank you, Speaker. Next speaker, please.
Hello, my name is Lillian Stielstra. Thank you, first of all, to all of you for still holding these meetings and holding our city departments accountable. And I hear the same frustration that the previous speaker said from Ms. Thompson. I think we wouldn't be at this place had the original request way back a year and a half, maybe even 2 years ago, been provided fully and completely. Instead, it was almost as if we'll give them a little piece of this and a little piece of that, but not everything. And so having to put together a little jigsaw puzzle. I live in the inner Sunset, and when we requested for information, we got an abundance of information, and we had to sort it out. Luckily, there was a team of us, and we could put together our heads, and we actually had organized people who could sort things out. And may I say, in some of those emails, one very telling one, where we were asking, where is all this money coming from? In an email by Jonathan Goldberg, who was then the Green Benefits District Manager, he was asking his supervisor, Nuru, and his finance manager, oh, the Green Benefit District people need a little bit more money to do this meeting and that meeting. Where should we go get this money from? And he listed 3 sources. The third source is, oh, perhaps a loan from one of our developers. So is our city indebted to property developers? Because it is certainly very scary to know that we can't get information about where the money is coming from, who is it being paid to, and how is it being used. Ms. Thompson, if you live in the city, you are paying those taxes too. Wouldn't you want to know how that money is spent? I think that the efforts to foil Mr. Hooper have come about because in the first 2 other attempts to
30
build
seconds,
out the
ma'am.
Green Benefit District, we will have enough information to put together a plan to stop these plans. But by the time the Mission District got around, they decided to hide as much information as possible, and this is where we are at today. So if it sounds a little paranoid, yes, it is. And I think, Ms. Thompson, you shouldn't be party to this plan. I feel sorry for you for having to do all this extra work, but it's certainly
Your time is up,
inappropriate
ma'am.
the way you responded.
Thank you, Speaker. Next speaker, please.
Hello, my name is Richard Harris. I live on Masonic Avenue, near Frederick in the Haight, a neighbor of Buena Vista Park. Is it possible that the Parks Alliance has records that are relevant to this? And if so, I believe I came in the middle of all of this, but at a point in which one of your members made a reference to a case, a legal case that says a contractor for the city who has the a municipality's records, or who is doing work for the city, those records are available because they are under the control of the city. So, is it possible that whoever was running the program at the Parks Alliance would have these records? And if that's possible, can you expand the investigating committee's request to seek to obtain whatever records Parks Alliance may have on this? Do you need an address for me, or did I give you sufficient information?
No, that's fine, sir.
Thank you.
Speaker. Thank you. Next speaker. Any other speakers on the motion? Okay,
Yes,
none.
yes,
Go ahead.
I have.
Speaker, go ahead.
Hi, this is Hank Heckel. I just wanted to comment. I understand the frustrations regarding this particular complaint kind of on all sides. I appreciate the task force's patience. And I'd just like to point out, I mean, the Sunshine Ordinance does not require a narrative kind of describing all the documents that have been produced and, sitting down with someone and going through it and answering questions. It requires working with the requester, finding the documents, and providing the documents. And I think that's what's been done here. It's been represented as such. And I think the problem is if you play this out, I understand the task force has suggested that before this goes to committee, Mr. Hooper make a list of items, and then, that would sort of specify things that he claims are missing. But I think that's happened in the course of this matter. There's nothing to stop Mr. Hooper from claiming that, once OEWD comes back and says, well, we gave you these items, we don't have anything else. What's to stop him from simply saying he doesn't believe it? And so I think the problem is, you can't just keep going back and forth on this merry-go-round. At some point, the representations of the city officials that are the custodians of the records, they're sort of bound by their obligations to accurately represent the production. And if someone can just keep infinitely and indefinitely questioning that, and you could just play this out ad nauseum, where he just comes back and says he doesn't believe it. And so I don't think that's a productive use of anyone's time. And I would also point out, with respect to the burden on time and resources, that the current emergency orders actually don't require city employees to be called to the task force to the extent they have COVID-related obligations. And I think Ms. Thompson has come out of a sense of good faith. But I think at some point the process has to come to a close. And I think we've reached that point. Thank you.
Thank you, Speaker. Any other speakers? Public comment. Okay, closing public comment. Are we ready for a vote? Members? Okay, hearing no objection, please call the roll.
Member Yankee?
Aye.
Member Yankee, was it Lila who's second?
No, it's me. Member Wong.
Member Wong,
Member
okay.
Wong.
Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Okay, thank you. Please call next item. And thank you, parties, and your patience and your time.
Mr. Chairman, one point of clarification. Am I sending my bullet points to Cheryl?
Yes.
Okay, thank you.
I look forward to getting them, Mr. Hooper.
Okay, thank you. Please call next item.
Item number 7, file number 19062, complaint filed by John Hooper against Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public workers request in a timely and/or complete manner.
Okay,
Oh,
both
do you want me
parties.
to read the? Do you want me to read the preamble?
Hold on. Let's find out if both parties are here first. Mr. Hooper, you're still here?
Still here, Mr. Chairman.
Okay. Is Department of Public Works representative here?
Public Works is here.
Okay, thank you. All right, go ahead, Cheryl.
Okay. On January 21, 2020, the task force referred the matter back to the complaint committee and requested that new materials provided for the task force be included in the file for review to determine which documents are applicable to which respondent and provided a recommendation to the task force. On October 20, the complaint committee determined that the records are public and referred the matter back to the task force for hearing.
Okay. So I'll ask again for the complaint committee. Is it the same call as the previous?
Yeah, it's essentially the same.
Same call. Okay, great. Okay, and so we are now at the point of deliberation. We've gotten through the rebuttals. So let's pick it up from there.
Are we putting a time clock on this? 5 minutes?
Well, no time clock because it's really in the hands of the task force now. Task force can make a motion, or can make the further deliberation, ask more questions. But ultimately, we're at the point of arriving at a motion.
Excuse me, Mr. Chair. Mr. Chair, this is David Steinberg. With the last item, which was heard at the same time, you went through the same 5-minute presentation by the complainant and the respondent.
Oh.
Are you not going to do that with this one?
Yeah, we can do the same. I apologize. You're right. I did start out that way. Let's do that. So, Mr. Hooper, if you're ready.
Thank you, Mr. Chairman. As I said before, and I'll try to keep a straight face, I will try to be brief. So, in the case of complaint number 19062 against Public Works, the department's position has been that Parks Alliance not received any grant or any contract from Public Works, and therefore is very limited in its ability to obtain information about this matter. So what I would ask you to consider are just the following. Public Works pays for a full-time employee with the job title of Green Benefit District Program Manager. The former program manager for several years was Jonathan Goldberg. The current DPW Green Benefit District Program Manager is apparently Ramses Alvarez. So that's all paid for by DPW. The former Public Works General Manager, Mohammed Nuru, personally promoted Green Benefit District. That's well documented, as did then Supervisor and now Mayor London Breeze. At least some of the funding to promote Green Benefit District originated with Public Works. All the funding from the failed Inner Sunset Green Benefit District campaign was provided by Public Works, and much of the funding for the Mission Dolores effort seemed to be a quote-unquote pass-through from Public Works to OEWD. We don't know how this worked, and that's a critical piece of missing information. Public Works was formally represented on the 3-member quote-unquote cities team, which overseeing and approving the core tasks and deliverables carried out by Parks Alliance in the appendix, which I referred to in the previous session just concluded. In the failed Inner Sunset GBD, Public Works was the lead agency involved. And Mr. Steinberg explained at your January 21st, 2020 meeting that OEWD took over the GBD program in the Mission Dolores effort at that time. All of the deliverables under the GBD-related contracts with OEWD must be submitted to the GBD program manager housed at Public Works. According to correspondence between Public Works, GBD Program Manager, and members of the defunct Greater Buena Vista Formation Committee, OEWD doesn't fund GBD. So where does the money come from? It clearly comes from Public Works. So all I'm trying to say is when Mr. Steinberg says that he's given me all he's got and he doesn't have any further responsibility, I contend that the responsibility of Public Works to go to Parks Alliance or wherever the documents I'm looking for are happening is not limited by the fact that his department doesn't have the contract. His department is up to its ears and has its fingerprints all over this program. And I believe the funding comes from Public Works, but I can't get to the bottom of it. So I'm asking you to find a violation because it's not a good enough excuse to say, we don't have the contract, we don't know nothing. Thank you.
Okay, thank you. Mr. Steinberg.
Hang on.
Where is Mr. Goldberg? I don't remember who's there.
No, it's David Steinberg.
Okay.
Okay, David, go ahead.
Okay.
Do you need a second?
Thank you. Nope, I'm good. Thank you. So Chair Wolf and members of the task force, my name is David Steinberg. I'm custodian of records of San Francisco Public Works. First, I want to congratulate Member Hinsey for her nomination to the MTA board. Now, in response to this complaint, I want to note that this is essentially the same complaint as your file number 19062, filed by Mark Sullivan, who's an associate of Mr. Hooper. In that case, the task force found that Public Works did not violate the Sunshine Ordinance in its order of determination, and we ask that you similarly make the same determination in this case. Our position in this complaint is simple. In response to his February 11th, 2019 records request, we released 43 documents to Mr. Hooper, totaling approximately 240 pages. In addition, we referred him to 2 previous requests that contained responsive records with 30 documents totaling approximately 600 pages. We have produced all responsive records and did so in a timely manner, having responded by February 20th. It's worth noting that Mr. Hooper, Mr. Sullivan, and a third associate have submitted more than 30 records requests related to green benefit districts, all of which have been fulfilled by Public Works. Like Mr. Sullivan, Mr. Hooper is arguing that San Francisco Public Works has an obligation to retrieve records from the San Francisco Parks Alliance, but we have no such obligation. Mr. Hooper is aware that OEWD, not Public Works, holds the GBD contract with Parks Alliance, and it's our understanding that OEWD itself has produced all responsive records. We should have been able to clear this matter at the January task force meeting, but Mr. Hooper tried to introduce new documents past the deadline set by the task force, so the matter was referred back to the complaints committee. Unfortunately, the public health emergency delayed the committee from meeting until October, and when it did, none of the documents from Mr. Hooper had anything to do with the complaint against Public Works. So now we're back before the full task force. In summary, we've provided all of the documents responsive to the February 2019 request that are held by this department. Mr. Hooper's argument that there's an obligation to obtain records from a third party does not apply in this case because the San Francisco Parks Alliance has not received a grant from Public Works. For these two reasons, we ask that you follow your precedent in Mr. Sullivan's complaint and similarly find no violation of the Sunshine Ordinance in this case. Thank you.
Thank you, Mr. Steinberg. Okay, members.
I guess I'll go first here. So I am looking at our packet, which would be page, at the bottom would be page 1603 if it existed, but it's the one after 1602. It doesn't look like it got stamped. And this is Mr. Hooper's most recent correspondence. This was after the complaint committee meeting that we had. I don't see any particular, unlike in the prior case, I don't see a particular list of documents here that he still seems to be looking for. I see, he has various, arguments he wants to make, but I don't see a list of documents on this page that he's still looking for from Public Works. And since OEWD has the contract with Parks Alliance, I'm not sure how Public Works is even in a position to help them gain those documents that we just kind of talked about in the prior file. So I'd be interested to hear what the other members think, but I'm starting to think that at this point we might want to finally resolve this pending issue with Public Works as a respondent.
I have a couple questions for the witness or for the parties.
Go ahead,
first,
Member Schmidt.
Okay, thank you. First, Mr. Steinberg, you said that DPW doesn't have an obligation to do anything with regard to Parks Alliance because it's not DPW's grant. Could you tell me why do you think that's the case?
Well, our generally the obligation to produce records is if we have possession or control of the documents. We produce everything we have. I'll point to page P1591 of your packet. This is the June 2019 summary from your DCA that notes the complainant contends that respondent has an obligation to obtain records from third parties. As the San Francisco Parks Alliance, respondent contends that it has no obligation to obtain and provide documents from that entity because that party has not received a grant from Public Works. It's unclear whether respondent has contractual relations with other relevant third parties or has a right or obligation to seek documents from them. And then it has a footnote saying, in complaints May 29, 2019 submission of the task force, he asserts that the city's benefit districts in several San Francisco neighborhoods, as noted above, under the jurisdiction, it is unclear whether OEWD is actually the proper respondent in this matter, as opposed to Public Works. And if so,
do you think OEWD would have an obligation to go to Parks Alliance and ask them?
Well, I'm reading what the DCA wrote, which said that it's unclear whether the complaint was filed against Public Works.
What's your position? Your department's position?
We don't believe we have an obligation to go to Parks Alliance. If anyone did, it would be OEWD. But as the DCA notes, it's unclear whether, even if that's true, any of the funding was provided by the respondent. In any case, whether it was triggered an obligation for the respondent to seek additional documents from the third party. So, if there is an obligation, it would be on OEWD, but I'm not sure that's even the case. But it certainly wouldn't be an obligation of Public Works.
And again, why is it that OEWD, because there's a grant with Parks Alliance, that only they would need to respond to a request by going to Parks Alliance? What's your basis for that? Is that based on the DCA's opinion?
In part, and what has been explained to me from the city attorney's office is, again, usually if I have the documents, I have to provide them, of course, or if I have some sort of control over them, I have to get them. In our case, we have neither possession or control of them, because we don't have a contract with Parks Alliance for this matter. If there is such an obligation, it would be with OEWD. But again, it's my understanding that they provide everything that they have.
What is your working relationship with Parks Alliance? Do they just work with OEWD, or is there a working relationship with DPW and Parks Alliance?
My understanding is that there are other programs that Public Works has with Parks Alliance. I couldn't tell you exactly what they were. I couldn't tell you what the financial relationship or that, but yeah, I mean, I could try to find out, but I know that we've worked with them. I can't tell you what the scope of that is.
Okay, and you, with DPW and Parks Alliance, on this specific project, they met with each other in terms of negotiating the details of this project, right?
I don't know.
You don't know? Okay.
Again, it was an OEWD contract.
Okay. 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 That's all I have. Thank you.
Members, any other questions? Okay, I have a question, Mr. Steinberg. So we did hear testimony from OEWD in the previous case, which involves the same subject matter, that while they provided community engagement services by hiring Parks Alliance, they were not sure how that got paid. That it gotten paid by an ad back for some. So there's a lot of background noise. Somebody can mute themselves. Thank you. So my question is to you, is the Green Benefits District process program, is that not initiated by Department of Public Works?
I don't know if you can characterize it as initiated, but it is a program of Public Works. We provide support to neighborhood groups that are interested in investigating the formation of GBDs.
So when let's say a neighborhood group or a grouping of residents says we want to create a green benefits district, who are they referred to as being the lead? Who takes that call?
Well, if I understand your question, we have someone on staff who is his title is Green Benefit District Manager, and part of his responsibilities before he was dispatched to the COVID Command Center was working with neighborhood groups to sort of work through the bureaucracy and help them figure out how to potentially set up such a district.
But this is not a kind of an ad hoc kind of process. This is defined in policy or ordinance somewhere. and or in code, and it's got to start with somebody kind of controls the process. Is that your department, or is it OEWD?
I don't know that you could characterize it as any department controlling the process. If a neighborhood group, a group of neighbors, businesses, and residents are interested in setting up a community benefit district or a green benefit district, and they contact the city, I think they're probably given, information and support to, or information just to fulfill, help further their goals. We happen to have a person who he's the green benefits district manager. He does other things too, but he is someone who's available to help guide them through the process. I mean, it's kind of like, we have a permit center now at our new building at 49 South Van Ness, and it's difficult for like a small business to try to figure out how do we, it's the COVID emergency. How can I get a table and chairs permit in order to continue being in business during the pandemic? And so we point them toward the right place.
It's a help center. They're there to provide, help and guidance, but the complete, does the community have to go connect with the city at all for creating a green benefit district? At that point, it sounds like they can just create it.
No, they can. They don't have to rely on the city to have the meetings and discuss it and promote it. But actually, I believe, and I don't quote me on this, but I believe the legislation for actually creating it like a community benefit district does have certain requirements. At some point, it has to go to a committee. It has to go to the board of supervisors for a vote. It has to go to the residents and the businesses to vote on. But no one, I don't believe there's any obligation for anyone to have to talk to the city to try to plan for it until you get to the point of let's sign a petition to get this thing started. And at that point, there are certain requirements, I believe, that say, okay, once you reach this threshold and you get so many signatures, okay, it goes to the registrar of voters, and you're going to have to have an election, and whether that happens or not, and then it goes to the board of supervisors and things like that. But there's nothing that says that anyone has to talk to the city until they, until the point that they want to propose it. We just try to give them. I think we try to give them help.
Okay, gotcha. So be it as it may, money was spent to help both of these green benefit districts that the requester is asking about. And he's asking for an accounting of how that money was spent for this help, which may or may not, whether it's part and parcel of the green benefits district or not is really maybe of no consequence. It's really just really a question of accountability of how DPW is spending its money and who is contracting with who. And they want kind of a clear idea of what that is. So the question then becomes, what information do you have that the requester is asking for, and do you have any information, or do you not have any responsive records?
We did have some responsive records. As I said, we provided Mr. Hooper with about 240 pages of documents, and then referred him to the two other requests that were responsive. It was another 600 pages. As Ms. Thompson noted, Mr. Hooper, Mr. Sullivan, and Mr. Tomasevich submitted numerous requests about green benefit districts. I don't know how many they got. We got about 30 of them, and we responded to all of them and fulfilled them all. If I look at his actual requests, he's asking for, his request to us was for example, grant applications to OEWD contracts, verbatim transcripts, et cetera, et cetera, et cetera. I don't have those.
Who does?
Well, if anyone did, I would assume that OEWD did, and from what Ms. Thompson said, she gave it to him. All I can say, I mean, at its simplest, we gave him everything we had, and I really can't do any more. I mean,
okay.
I mean, honestly, we've, as I said, we went back to the complaints committee because Mr. Hooper came on the day of the committee hearing, or the task force hearing in January, and tried presenting new documents, which you wouldn't accept because it didn't allow the task force enough time to look at them. So we went to the complaint committee, which unfortunately was delayed because of COVID, and none of them had anything to do with public works. So,
okay, thank you.
Yeah.
So, Mr. Hooper, I'm reading your updated statement with regards to this case for today, and I'm not quite seeing what exactly you're asking for, what more you need or requesting at this point.
Thank you, Mr. Chairman. And it kind of goes back to the whole debate that occurred before your task force, whenever it was, a year ago, whether the two complaints should be combined because of their similarity. So I would just say that the information I would like, I can't, I used the term shell game before, and I don't mean to be derogative, but I'm afraid the best I can come up with. Kind of it's in nobody's shop. So the same questions, my 1A through 8, which I will now distill for you for future consideration, would apply equally to public works because, you've got a former general manager, Mohammed Nuru, who promoted the project. You've got a full-time guy who is called the Green Benefit Manager guy. You've got these people going out and creating the agendas for meetings, who are suggesting and putting new people on the local committees, which incidentally are completely divorced from neighborhood committees. In our neighborhood, the Hayter Street Neighborhood Council, a revered old-time neighborhood group, completely in opposition of the GBD in our neighborhood. These things are constructs of the city. They would like to lead you to believe that this is a bunch of neighbors who come up with this great idea that said, oh, let's ask the city for some help. It's the opposite. The city is going out and very aggressively and actively recruiting neighbors, many of whom have no history of neighborhood involvement. So as far as DPW's financial involvement, I have a document which is part of your record that says that $33,000 for the Dolores Park DVD came from DPW, and then there's a Public Works work order. It's in your record. I don't have the page number. $98,984 Public Works order FY 1819. So, again, going back to the top, you've got a full-time employee in DPW. You're obviously putting DPW money into this. You're going into these community groups and you're setting their agendas and you're scheduling when they meet and you're holding these public meetings. I don't really see, I understand David Steinberg's frustration and I appreciate all the work he's done, but I really don't think that Public Works can absolve itself. OEWD would like to point the finger at DPW, and DPW would like to point the finger at OEWD. I don't know who has the information. I think they both have an obligation. That's all I'm trying to say.
Okay, that's fine. Our point here is that the task force is not charged or doesn't even have the authority to oversee how a process city, operated administrative process works, whether it's working properly or not. If there's a lot of background noise, if somebody can mute themselves, please. Very hard
Sounds like
to hear.
someone taking a bath.
Okay, thank you. If you can, everybody please mute themselves, *6. It would be very helpful, and only the parties have themselves unmuted, because everybody is unmuted here. It would just be very helpful. Thank you. So the jurisdiction and the authority of the Sunshine Task Force is limited, and it's limited only as it starts with the Brown Act and starts with the CPRA. Okay, it has no other authority to determine whether a city program is operating properly or not, except with regards to, are they having proper public meetings or not? Are they producing public documents? Are they, putting up agendas, so on and so forth, that kind of thing. So we really cannot get into the weeds of this particular process unless there is a sunshine violation or sunshine aspect, compliance aspect with regards to it. That's the first thing. The second thing is you're looking for a paper trail with regards to dollars that are being spent. Here's a program, or here are people that are contracted. You want to know who the contracting agency is and what the money trail is for that. Okay, is that kind of the scope what you're looking for in this particular case from DPW?
Well, if you're asking me, I think the dilemma lies in the fact that two city agencies are intimately involved in the benefit district programs in the city. And for a member of the public who becomes concerned about the whole thing, it's very hard to sort out where the responsibility lies. And as I've said before, and I won't repeat, there are umpteen reasons that DPW has its fingerprints all over this. And I don't think the fact that DPW just doesn't have the contract lets it off the hook. It's got the guy who runs the program. It's passing the money through the OEWD. I mean,
but where is the transparency issue here? Okay, that's the thing. That's what we're here to help with. That if there is some non-compliance of transparency, tell us what information you're trying to get so we can determine whether it's actually public or not, and whether it exists or not. And because otherwise we're going to end up going down a rabbit's hole. And we're not here to adjudicate whether the program was properly administered or not. That's not our job.
I think one thing he's looking for is public records that are in the possession of these of Parks Alliance and all these other various entities that are out there that work in this web of private public connection. And those are public documents he's trying to get, and everybody's telling him they don't have to do it, when in fact I don't know if that's the case.
Right. So the point is what documents now for this case are we looking for? And
well,
let's get the focus on that, because reading everything I've read in preparation for this case, I'm not seeing exactly what documents you're trying to get. I see that you don't think that the process was appropriate. You don't know who is connected to who, but I'm not looking like what documents can we help you get.
Thank you. I think the easiest way to look at this is I don't know who to go to because I keep getting the finger pointed at somebody else. I want the same documents, and I don't care who gives them to me, that I listed in 1A through 1H in the prior discussion item 19061, which you've asked me to further distill and send to Cheryl. It's the
Right.
same list. I don't know who has them. All I know is that it's not proper for the Department of Public Works with its fingerprint all over this to say, we don't know nothing.
Okay, thank you. Members, so I'm going to maybe make this somewhat the same suggestion as we did with the last case. The Sunshine Ordinance requires that when a requester makes a request for documents under 6721, if the custodian does not have responsive records, they are required to provide some assistance as to where they might find them. And considering that both OEWD and DPW have a hand in the green benefits process, either in supporting a supporting role for the community or in actual administration of the program or the process after a certain point, there is some involvement and some connection with the city at this point. And money has been spent, and there are contracts. Obviously, both parties, all the parties have agreed that there are, they have people either hired on staff or they have contracts. So I think at some point it's incumbent upon the respondents to be able to help the requester get the information that he needs. So I would enjoin, and maybe that's not the word, I would join DPW with OEWD in the previous case under the same purpose and have that all in one meeting and have them have it figured out by the complaint committee.
Mr. Chairman, can I make a comment to that?
Who's speaking?
Sorry, this is David Steinberg.
Yes, Mr. Steinberg.
I completely understand what you're saying. I will just say what I said before. We have provided everything we have. We don't have the ability to get anything more. If that isn't sufficient, then just find me in violation and be done with it, because I don't need to go to another 2 to 6 or 10 more meetings, because there's nothing more that I can produce. And I haven't been working since 7:30 in the morning like Ms. Thompson, but I've been working since 8 this morning. So there's literally nothing more I can do to give Mr. Hooper or Mr. Tomasevich or Mr. Sullivan what he wants. And as I said, in a previous request or complaint by Mr. Sullivan, which was virtually identical, the task force made a determination that we did not violate the Sunshine Ordinance. So I would beg you not to send it back to the complaint committee and find that we are not in violation of the Sunshine Ordinance.
Thank you. Okay, I'm just going to have task force members deliberate and come up with a some sort of action or no action at this point.
If I may, then I'll start it
Go
off.
ahead.
To me, it sounds like Public Works has delivered all the documents that's in their possession, and I think that's an excellent point, that they obviously need to point the petitioner to the appropriate party for the documents that they don't have in their possession. And I think they've done that by referring them back to OEWD, who's the contracting agency. And so I think it's OEWD who needs to, as we talked about in the prior case, who needs to figure out how to get any remaining documents that might still be out there if they're held with Parks Alliance or what have you. But I'm just not at this point seeing the connection with Public Works any longer. I think that they may have, well, it sounds like they have turned over everything they have and have made that subsequent step of referring the petitioner to the appropriate party to receive the rest of it. And so I think I'm seeing this more of an issue with OEWD, and I'd be more inclined to resolve this with Public Works. I'd be interested in your opinion.
Are you making a motion?
Not yet necessarily, but
okay. putting it out there?
I think I'm more with what Bruce is saying, is that we treat it just like with the other one, just because I'm not sure if I see that DPW is so far separated from this whole thing that they have nothing to do with Parks Alliance for purposes of what we're trying to deal with here. That's my thought on it.
Anybody else? Okay, so is there a motion?
All right, go ahead, Mr. Member Schmidt.
No.
I was going to say, at this point, then I would find no violation in regards to Public Works.
Okay. Is there a second?
I'll second that.
Moved by Vice Chair Yankee, seconded by Member Highland. Any further discussion on the motion? Okay, we'll go to public comment. This is public comment for everyone except for the parties, and it is public comment on the motion. Please unmute yourself. Or 6. Go ahead, speaker.
Hello, this is Lillian Steelstra. May I speak?
Go ahead.
Thank you. I'm hearing similar frustration from Mr. Steinberg, and I think at this point in time, what the public wants to know is where is the money coming from. And in 2 previous failed efforts to set up green benefit districts, it was very clear the sources of funds. The finance manager was involved, and the chief of your department, now under investigation, was involved. So I think the records are which budget was taken to fund the meetings, to fund the website, to send the money to OEWD, to send it to Parks Alliance. So there's a chain of payments, because nobody works for free. In the Inner Sunset, $156,000 was spent, $200 an hour to consultants with an organization now defunct, because they were very clever to merge themselves into SF Parks Alliance. So there is information. It resides in your finance department. You should be able to produce payments from DPW or from budgets allocated for street swimming, rediverted somewhere else. The money trail will tell us everything. And if you can't find it, Mr. Steinberg, I suggest you get your finance manager involved, because nobody works for free. And before this committee, decides to dismiss this and say it's not tied in, it is very tied in. And the reason we're still here today is because back and forth. We've been told, oh yeah, we don't have this, but you go there. Oh, we don't have that, you go there. They do that to you in communist countries. Stand in this line and get this number, and then you can get this information, but then you find out actually what you got was a ticket to go stand in another line. So this whole hearing just sounds exactly like a Kafka sequence to me. But I'm suggesting before you
30 seconds.
It, please dig up the finance records, get your finance managers involved. Thank you.
Next speaker, please.
I'm sorry, may I speak? Is somebody else speaking?
Nope, you are.
Hello.
Go ahead, Anonymous.
Hi.
I can understand, again, and I think this is even in a different sense, the frustration of Mr. Steinberg and frankly, the previous respondent whose name I don't remember. But I think the problem here is that's because the malfeasance is not necessarily
Anonymous?
with the person who has the title. Yes. Hello.
Yeah, we lost you there.
We
Hello,
lost
can
you
you hear
for a
me?
bit there.
Hello. Okay. I was saying that I can understand the frustration of these respondents here, and that's possibly because whatever malfeasance occurred is not something they're aware of. But this is actually another shell game, because the only person who has to stand here and answer for this are these lower level employees, when whatever actually happened may have happened, one, by a director who no longer works there, and two, by higher level employees or employees in other parts of that department, as the previous speaker was saying. And so it ends up with a poor result for everyone. Mr. Steinberg may be genuinely and truthfully saying that he can't give you anything. But that doesn't mean that the records didn't exist, that they weren't destroyed, that they're not, quote, in the care, custody, or control of the Department of Public Works. And I do think you need to investigate whether those records and other third parties, non-public entities, if they are considered within the care, custody, or control of the Department of Public Works, or if they existed at the time of the request and were later destroyed, which would be a violation of various retention laws, including a very specific rule that says once you request something under CPRA, you can never ever destroy it as long as the appeals are pending. So I don't think this makes sense, but I can also see why it's not necessarily Mr. Steinberg or Ms. Thompson's fault. These are questions that need to go to right to the department head, who is legally responsible for the implementation of the Sunshine Ordinance within their departments. Thank you.
Next speaker.
This is Richard Harris again.
Go ahead.
Go ahead, sir.
Yes, the name is Richard Harris. I live on Masonic Avenue near Buena Vista Park. Similar point to the one that I made earlier. Either or both DPW and the OECD are in a position of control, so they would have control of records at Parks Alliance that would have to do with invoices from Parks Alliance to either OECD or DPW or whoever has been paying those bills. And there's been reference at a couple of points to the issue about if they're under the care, custody, or control, then that department is responsible to go get the document. So either OECD or DPW will have the ability to request the documents from Parks Alliance. I'd suggest that you not drop off Department of Public Works just yet until it's clear, so that you don't get this game of one of the departments pointing a finger at the other. You've identified the two departments that are involved, and I would suggest you get it straight that way, and then maybe both of them put in a request to get the documents from Parks Alliance. That's the end of my comment.
Thank you. Next speaker. Last call for public comment on the motion. Last call. Okay. Public comment is closed. Members, back to you. Are we ready for a vote?
Sure. I'll just say before we vote is that I absolutely share the concern with a lot of the commenters that it is very difficult to figure out where these documents are coming from, and I think that's why we have to figure out and narrow it down to who specifically within the city, which agency is the ultimate responsible party. And I think in this case, we've determined that OEWD is the contracting agency. And I think it somewhat muddles things to have multiple agencies involved, where they can kind of go back and forth and say, well, no, that's DPW, no, that's OEWD. I think it helps to narrow this down to one final responsible party. And I think because that is OEWD, that's where we should focus on to get these records and to get everything worked out for the petitioner. And so that's why I think it's helpful, in fact, to remove DPW from this. They've given what they have and have now referred it back to OEWD for anything that they don't have, which we know is that contracting agency. So that's where I think the ultimate responsibility lies. And I think that's where we can do the most help in the complaints committee going forward. So that's all.
Any other members, comments? So my last thought on this is I don't think DPW should be divorced from this. And I'll tell you, the reason why is because they do have somebody actually on staff that specifically helps with this particular process. It's a multi-agency, multi-department effort when residents want to create a green benefit district. First starts, as I mentioned before, and as Mr. Steinberg explained, it starts out being like in a consultant role to help and support the public in getting the process rolling. And then when the public has got all their ducks in a row and presents it to the city for official implementation through whatever the process is, got to go through a vote, some sort of ballot initiative. Then the city is more activated to make it happen, and there's more definitive roles that happen. Since it never got to that point, money was still spent. The requester is asking for who spent what where. I think these folks work more or less as a team. I think when they have their kind of public meetings, they're all there in the room. And I think that they shouldn't necessarily be divorced from it. I submit that I think DPW should help with OEWD because they do have a part to play in this. And that if they have some insight as to where certain documents exist as part of this process, then I think they should be helpful, despite how helpful they have been so far. And, I think just to get some closure on this, I don't think there seems to be that much more to do.
I'd have to pretty much say the same as that, is that I don't see how we can look at DPW, who is so involved in this whole process in every step of the way, and then they can suddenly say, whoa, we didn't actually sign the deal, so we don't have to do anything with regard to Parks Alliance, public records, etc., on that whole thing that we're dealing with. So that's sort of my take on why I think DPW may still need to be in this.
Okay, anybody else?
Yeah, I think I was ready to say that simplifying things might help the petitioner get what he's requested sooner, but actually the more I think about it, I think you're right. I know it may cause complications in terms of which department is responsible, but I do think that you're right, that DPW needs to be remained involved in the process.
And I'm exactly where Lila is. I was ready to simplify things, but the discussion, I think DPW still needs to be involved in this process. So, yeah.
Okay, so now hearing some of the debate here. I don't know there's enough votes or enough support to approve this motion.
I'll
Would
withdraw
the
my-
maker like to either rescind or amend it?
I'll rescind it.
Okay. Is there a new motion?
I will go ahead and make the motion to refer this matter back to complaint committee and have Mr. Have Mr. Hooper produce. He argues it's the same list. We can go through that at the complaint committee and sort of see where we're at. I would also need to make sure that we make a note to put these items on the same complaint committee agenda.
Well,
Yeah.
are you suggesting that they be it all be the same meeting?
Yeah, at the same meeting of the
Okay.
complaint committee. Not
Okay.
combine the files, no, but it's covered in the same meeting.
You want it to remain as two files, separate files?
Yeah.
I mean,
Yeah.
so let me clarify. I just want to make sure that I'm understanding you. Are you asking that DPW have a separate meeting than with Mr. Hooper from the OEWD meeting with Mr. Hooper, or have them all three meet together?
Oh, I didn't know they were going to meet offline. I missed that.
That's what we just did in the previous case.
Okay. I was just saying we could put these two items on the same complaint committee agenda.
Okay, I'm going to suggest that we add DPW to the meeting that is being set up for complaint committee with OEWD, since it's the same subject matter.
Right.
And we're talking about, that we do it all, have one meeting with the three parties.
Yep. Yeah.
Okay. Is there a second to that motion?
I'll second the motion.
Okay, so it's moved by Member Hensy, second by Member
Yes.
LaHood. Yes, second by Member LaHood. Any comment, any discussion, further debate on the motion before I call for public comment? Okay, public comment on the motion to bring them in.
This is sorry. This is David Steinberg. I am not allowed to make a comment at this point. Is that correct?
Generally, no. The parties don't. Once we make our motion, the parties, have already spoken. This will be our order of determination at this point.
Okay.
Thank you. Members of the public who are not parties. Okay, hearing last call for public comment.
Yes.
No. Okay. Yes.
Yes.
Okay. Go ahead, speaker.
Yes. Please. Can
Who is
sorry,
this?
I guess you can't hear me. I'll try to. Hi, this is Anonymous. Can you hear me? Hello.
Yes. We can hear
Okay, I guess I'll speak very loudly. I think this is the right thing to do here, but at the end of the day, you can't really, I don't think you can, under the procedures or the Sunshine Ordinance, hold kind of both of them or either of them responsible. And so at the end of the day, you need to determine, are you holding the head of DPW responsible, or are you holding the head of, I don't even know what the other acronym is, OEWD, OECD, whatever it is, or both. But it's like you have to finally determine, in order to do that, it seems like you should have the same kind of direction to DPW. Here are the things they claim is missing. For each of them, they have to say, do I have the record? Here it is. I don't have the record at all. Here's assistance to go where you want to get it. Or I'm withholding the record in entirety for this reason, or whatever else it is, as they would normally have to do anyway. And just do it for all of them, because otherwise, this is just going to keep on going on. I've been at some of these meetings for this case. This case has been going on so long, and the petitioner never gets any real relief. And frankly, I don't know what, I guess they're going to say the same thing. Respondents are going to say exactly what they've already told you. So unless I would say there should be more direction, exactly what the respondents have to do in both of these cases. Thank you.
Next speaker. Okay, closing public comment. So the purpose of sending it back to committee is to determine if the records exist. The committee will then return it back to the task force with their findings and whether there was a compliance issue with one or the other parties with regards to the respondents at that point. For instance, with the previous case, the OEWD said they provided documents. The petitioner said that they never got them. Okay, that's another opportunity for the respondent to be able to produce the document. Okay, so that is kind of the order of things at this point, and leaving the complaint committee with the latitude to try to bring this to a close, and then report back to the task force with any recommendations with regards to compliance issues, violations, and otherwise. That's the charge. Okay, are we ready for a vote? Okay, let's call the roll.
Member Hensy?
Aye.
Member Hensy, aye. Member LaHood?
Aye. Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye. Aye.
Chair Wolf, aye. The motion to refer this matter back to the complaint committee, and that the two matters, 19061 and 19062, remain as separate files.
Great, thank you. And sorry it's going this way, everybody, but you know, it's the only way to get to any kind of closure, I think, at this point. So thank you for your patience and for attending these very hard times. It's appreciated by all. Okay, let's go to our next item.
Item number 8, file number 19140, complaint filed by Stephen Malloy against the Department of Human Resources for allegedly violating Administrative Code Section 6721 and 25 by failing to respond to a request for public records in a timely and or complete manner.
Okay, so this is not a referral back. Okay, so complaint committee. You have any brief, anything you want to report?
When was it heard, Cheryl?
September 15. It was at the very beginning of when we started hearing cases.
That's right. I don't remember much about this one particularly. Do any of my members remember? No. Okay.
Not offhand. I don't recall this one. I'm not sure I was on complaint at that time though.
That was before me also.
I'm not sure who was. Yeah.
Okay. Well, let's move it along, and we'll get it. You have all the documents in front of you.
Member Wolf. Member Wolf, may I?
No.
Quickly.
We will start with,
I'm fine.
no.
I've just been holding for 5 hours, and I'm on a call with Australia right now. And can you give me 5 minutes to come back to you all to speak? Because I'm between two things and two worlds right now.
Okay, can we take a 5-minute recess, folks? Let's take a 5-minute recess. We'll return back here Let's say we're turned back here at 9 o'clock. Okay?
Please
Thank
let
you. I can
everyone
come back
please
in
mute
after
your
9.
microphone because we're going to let the recording run. We can't pause the recording. So please mute your microphones.
Yes. Please mute your microphones. Thank you.
Oh, Chris is adorable.
Testing. Testing.
You're good.
Okay. Thanks.
Is Mr. Malloy with us?
Finally got this worked out. Okay, I'm going to ask, is everyone back? Member LaHoods is here.
Yes.
Okay, Member Highland is here. Member Wong. Okay. Is everyone here?
Yep.
Just
speak up.
I'm here.
Okay, great. Great. Okay, so let's get back to it. We're back on the clock. Mr. Malloy, are you ready?
Please press *6. You may have been muted while you were off.
Mr. Malloy, are you there?
Yes. Can you hear me?
Yes, we can hear you.
Okay. Yeah.
Very good. Okay, one moment, please. Is the representative from DHS here? DHR, I mean. Is there a representative from DHR?
Bruce, can I say something?
Yes.
Yes, I don't believe Human Resources was noticed. I sent an email to Maggie McHale, who is the custodian of record, and as I recall, Department of Human Resources was not available for the complaint committee hearing as well.
Did they send notice that they weren't coming to this meeting?
I didn't see anything from them.
Oh, you didn't see. Okay.
I didn't see when I sent out the initial notice of the task force meeting. I didn't see an email from them saying they couldn't make it, and then when I sent out the packet, I sent it to them, and I didn't see an email then saying that they couldn't make it. So they've gotten at least notification twice.
Okay. All right. Very good. Okay, members. How do we want to dispense with this?
I checked the meeting minutes from the complaint hearing, and they did not come to that hearing as well.
Yeah.
Shall we proceed?
I would say at this point we should proceed. They're just
okay.
Back to the show.
Okay, then let's proceed. We'll hear from the petitioner, Mr. Malloy, first. You have 5 minutes. Cheryl, let him know when you're ready.
Okay. Go ahead, Mr. Malloy.
Okay. Thank you, members of the task force. Thank you for also taking that quick break there. I was toggling between a meeting with a speaker from Australia, so I appreciate you doing that and for your service. I did want to ask, thank you, Cheryl, for setting up the agenda. If you, as I'm sure you already are, in my complaint, if you could go to page 239 out of 328, or page 2273, you will see there that the Human Resource Department cited the improper citation for their justification in withholding. They did not cite their responsibilities under the Sunshine Ordinance Task Force. And so 6726 for improper withholding, I feel should also include for failure to cite and follow the appropriate laws. Little history at that point in the process. I had originally filed on November 5th of last year. And then the task force gave an extension to the Department of Human Resources on November 7th. They gave them a second extension on January 14th. And all that did was lead us, if you scroll forward to page 253 to 256, which is pages 2287 to 2289, you see the improper redaction, where they just merely blacked everything out against the law. If you then scroll forward to pages 265 to 267, or 2299 to 2301, you will see the 11 city officials, including the mayor, who had communications concerning Stephen Malloy in public records. You will even see on page 266 that Human Resource Director Mickey Callahan and Susan Gard at the time, who was her policy, say specifically, can we meet? So not only do we have the violation under Sunshine Ordinance, we also have the violation, I believe, based upon this evidence, of the Ralph Brown Act as well. Because I've not been provided any records other than those blacked out redaction pages and these immediate emails that you see from the 11 city officials. And so there were meetings, there were notes, there were texts, there were a whole series of things that took place that should be provided that have not been under the law. If you then go to page 272, or what is 2306, you will see that part of the reason I'm calling for 6727 is that as an independent contractor for the city of San Francisco, Mickey Callahan and the Human Resource Department must conduct an investigation for discrimination when called for. And so what these records are concerning is the city's refusal to provide me that equal right under the EEO policy of the city to investigate discrimination at Department of Public Health, which you've also ruled on in the past. And so going forward then, and finishing up on page 275, or what is 2309, you'll see that I first contacted the Department of Human Resources on December 17th of 2018, prompting these emails because I was asking for that investigation of discrimination, which Mickey Callahan blacked out everything, had conversations with Greg Wagner and Department of Public Health. The mayor is involved in that. We now know the city attorney was involved in that. And so that's why I'm asking for 6734 on misconduct, for willful noncompliance, and 6726 as well as the other ones that I cited in my complaint. I did want to ask also that on the DPH complaint, which was 19109, on September 2nd, you authorized the Ethics Commission investigation. And I also requested that it go before the Board of Supervisors. Here we are, December 2nd, and Ms.
Your time's up, sir.
Cheryl, thank you. Cheryl responded to me, but I still have not heard anything on that Ethics Commission investigation. Thank you.
Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none, respondent? Okay, respondent will note that the respondent is did not appear, so we'll ask if there are any persons or witnesses to provide any facts or evidence on behalf of the respondent. Okay, hearing none, members. Question and answer clarifications.
I have a question for Mr. Malloy.
Go ahead.
Mr. Malloy, you showed us the redacted email. Did you receive any other information that explained what was redacted in that email?
No, I did not.
Thank you.
And Mr. Malloy, so what you showed in the redacted email is that you then got the unredacted emails later?
No, I received nothing other than what I referenced to you in those emails from the officials and then the redacted. They never did anything else similar to not responding or coming to the complaint meeting. They just ceased communication.
So what starts on, I guess it's page 265, the PDF 265, and footer page 2299. Is that part and parcel? Is that what's been uncovered by the redaction, or is this something in addition to the redaction?
As far as I know, what you're seeing is what I have seen, and what you're seeing is what was communicated to me. I don't know anything else other than I'm asking clearly for those 11 officials to give me the records concerning this, and there are more than that. But I haven't received anything, gotten any call, nothing. The respondent simply has not followed the law and then just threw out this information and then never responded. They never did anything.
Okay. So you did receive the documents that were redacted, correct?
Correct. What you see is what I got.
Okay, got it. Okay, so there's that redaction issue. Okay. Yeah, you said it kind of in a general way that there's other documents. What other documents are there?
Well, what I'm saying is that you see I initiated the request of Human Resources to follow the law and engage in the lawful investigation for discrimination that they were supposed to. That prompted Director Callahan and Susan Gard and Greg Wagner and the other officials, and the 11 of them, to begin communicating about that, which they started shortly thereafter in January. And then that's it. But we know that's clearly not it. You subsequently had testimony from DPH that the city attorney shut them down, is refusing to release the records that they have gone on the record and said that they have. So there's communications, there's clearly written records. They're making a willful choice to not provide any more of those and to just cease communicating.
I understand
I don't know, because again, I'm not, you're asking a great question, but that shouldn't be asked of me. I'm not physically in their computer system to make that determination.
But we don't know either. So if we ask them, they can tell us anything. So if you're requesting specific records, then we can ask them if they have them or not. Otherwise, we don't know what to ask for.
That's all. You've asked for them repeatedly in my Sunshine Ordinance request, going all the way back to November. We've repeatedly asked for those officials, the records, and they're just not releasing anything.
So I don't understand. What is
release all written communications concerning Stephen Malloy? That is not all the written communications concerning Stephen Malloy.
But what's the difference between this complaint and the previous complaint?
What do you mean the previous complaint?
So you had another complaint with us prior. Was that was with DPH?
The Department of Public Health.
Public Health.
Right,
okay, got it.
And the
okay.
region.
Right. Okay. So this is with DHR. Okay.
Mr. Malloy, is this anything more than a claim of attorney-client privilege? Are there other privileges or exemptions that you've been told are brought into play in this case?
I've not been told that there's any attorney-client privileges that were invoked. I've not received any information from the respondent in that regard. I've just seen what you're seeing. That is the extent of the respondent's response. So they've never invoked that as far as I'm aware of. The only thing that I'm aware of is what you are, which is when the DPH records clerk, Veronica Vane, confirmed that the city attorney had told her the illegal order of not to release any of my public records. So I imagine when they did that, of course, that order would extend to all records in any other department as well. And so similar to how Veronica Vane and DPH ceased, as you see Greg Wagner is part of the communication in these emails, DHR also ceased based upon the illegal order of the city attorney. But there was never any document sent to me that invoked attorney-client privilege or invoked any other than the improper citation from CPR that he was following the redactions under the California Public Records Act, which he can't follow that. He has to follow the Sunshine Ordinance Task Force, and he didn't redact correctly.
You said something about an illegal order of the city attorney. There's not really like some kind of an order, is there? You're just talking about how maybe there was some kind of advice, right?
Well, no, we know from the DPH previous case from September 2nd, when you all issued the ethics investigation request, that the public records clerk for Department of Public Health, Veronica Vane, confirmed that the city attorney, whoever that is, but that the city attorney's office had told her to not release any more of my public records.
Right.
Because she had released those 9 emails. She had them on her desk, but I've never received them, which was the impetus for that ethics investigation. And when they shut down DPH, which makes sense because you see Greg Wagner is communicating with Mickey Callahan about the very same information in these emails within DHR, it ceased with them just like it ceased with DPH. And when I say illegal order, clearly you have to release the records. They're not releasing the records, nor are they making.
So nobody ever told you like a privilege applies or an immunity or an exemption. Nobody's ever informed you that any of those protect the records, despite the fact that those would be public records, right?
Correct, not from DHR, though.
Okay, thank you.
This is Member Wong. Just in response to that as well, if you look at page 287 of the PDF, page 2321, in the footer, I think the only 2 references made for the 2 reasons for the redactions are sections California Government Code 6254K and then 6254P2. I think K cites privilege. But yeah, just wanted to point that out.
Excellent, thank you.
6254K. 6254K records, the disclosure of which is exempted or prohibited pursuant to federal state law, including, but not limited to, provisions of the evidence code relating to privilege. Is that attorney-client privilege, Dean?
That would probably be pretty, it would probably just cover any kind of privilege. Yeah.
Okay.
Including attorney-client, which is usually the first of the privileges in my business.
Okay. And then P2 is records of local agencies related to activities governed by Chapter 10, commencing with Section 3500 of Division 4, I don't know what that is, that reveal a local agency's deliberative processes, impressions, evaluations, opinions, recommendations, meeting minutes, research, work products, theories, or strategy, or that provide instruction, advice, or training to employees who do not have full collective bargaining and representation under that chapter. This paragraph shall not be construed to limit the disclosure duties of a local agency with respect to any other records relating to the activities governed by the Employee Relations Act referred to in this paragraph. And this particular 6254 is not required to disclose. It's not a prohibition. It's not a requirement to disclose any of the following records.
I mean, not having the other side here, I can't exactly say, oh, this sounds like the kind of things that would be attorney-client privilege protected, but it's conceivable. And, this kind of thing, you would want to, in a courtroom at least, you would probably go to privilege law, and you would require them to list the documents and talk about, okay, who's the communication between, to make sure that they're privileged communications, assuming that that's what they're relying on here. And at least in that footnote, it sounds like maybe that's where they're going. And this is an HR issue, which always includes a lot of attorney-client issues, privilege issues.
To completely be redacted. And under, I think the petitioner is right, under the ordinance for San Francisco, they have to provide the footnotes and the citations for each of the redactions, which obviously are not here.
Yeah, it seems like that complete redaction is pretty amazing. That they could, at least leave a period or something,
Yeah.
Okay.
Conjunctions.
Yeah, there's nothing there.
Names should at least.
It's like a barcode.
Yeah, this is Member Wong again. So Chapter 10, which is referenced by 6254P2, actually I think specifically refers to employees in public agencies in the state of California. So I don't think it's specifically referencing local agencies.
But he was with a public agency with UCSF was a contractor for the city. So he wasn't it wasn't like he went to UCSF and went to work for UCSF per se, and I'm sure he'll correct me, but it was UCSF was hired by the city to perform a certain function. So at that point, he was contracted by the city by proxy.
I would guess technically the employment contract would be between him and UCSF, but that doesn't mean, there's a lot of different ways in which that he's a joint employee under the law, probably of the city. In other contexts, he's not a joint employee, but there's so many different ways that employee can be classified and defined that I don't even want to say that, but he was a UC employee, it sounds like, at least.
Right. Okay, Mr. Malloy, I have a question. I think you said something about 6726 should also apply based on our page 2273. Was that the redaction issue?
I think if you go to page 239, let me back up a little bit myself. So on page 239, Mr. Vaughn, scrolling back
that's the
here.
That's the same paragraph. So this is the redaction issue, right?
Let me get there. Yeah, so he says this was November 14th of 2019. He says, hey, we found those responsive records. Please see attached for the redacted. and that they base it upon 6254 in California Government Code 6254, page 2, and has redacted the identifying information in the attached records. And they are committed to the Sunshine Ordinance Task Force for redactions and how they redact.
Right. It's actually to the Sunshine Ordinance. Yeah.
Yeah.
Yeah, it's to the Sunshine Ordinance, not necessarily to the task force. We just
right.
Look for compliance. So, okay, great. Okay, so I got that one. What was the other questions? You said there was a violation of the Brown Act. Where?
That was page 266, where Susan Gard and Mickey Callahan are communicating about me with Director Wagner, I think, copied, and others, and they're saying, can we meet, have that discussion about these issues, for example, that you all are asking questions about. So if they did meet, I don't know, because they're not providing records, it appears, right? Or if they're redacting incorrectly. If they did meet, and who did meet, and what did they talk about? And so that's why I'm indicating that it appears the Ralph Brown Act may have also been violated, because if they were meeting and I was that subject and they were writing and communicating about that and texting about that, then those records should be provided. And if redacted, then they should be redacted accordingly.
Yeah, the thing is all these people in this group, are they part of a commission or a board?
I don't know. I don't think so. I don't know, though. I wasn't at the meeting. I don't know. All I know is I'm the subject of the meeting, that they're generating records about me as the subject of the meeting. And then they're just blacking everything out. So I don't know.
It doesn't necessarily rise to it being a public meeting. Or even, I mean, the question then becomes, was it a passive meeting at that point? Or, you know, and it may not be. It may be, you know, in the course of regular business, you know, it's all employees kind of thing. You know, and they're meeting with their contractor. So, let's see.
The subject of the meeting was my request for them to do the lawful investigation that they were committed to, you're correct, by proxy, to conduct for me as their independent contractor. So it was specific. It wasn't in general.
Right. So I don't think that it's a passive meeting. So under 67.3C4, quote, passive meeting body, unquote, shall not include a committee that consists solely of employees of the city and county of San Francisco created by initiative of a member of the policy body, mayor, or department head. So if UCSF was a contract hire, then they would be considered, I would think they would be considered an employee. So that wouldn't make it a passive meeting. Yeah, the question is are they meeting as, you know, somewhat of a deliberative body, you know, or is it like specifically an advisory board or a committee? Well, wasn't created by the Board of Supervisors, wasn't created by initiative of a policy body. It's not a standing committee that you know of. We don't have them here to answer that. The passive meeting bodies are really for the executive branch. Advisory committees created by the initiative of a member of a policy body, the mayor or department head. We don't know if this is an advisory committee. Here's another one. Any group that meets to discuss with or advise the mayor or any department head on fiscal, economic, or policy issues. Not really. It's not social, recreational, ceremonial. And it doesn't have anything to do with homeless or welfare or public health or safety. It's purely seems like any human resources issue. I don't know that that flies, Mr. Malloy. I think for the purposes of the redactions, yes. I think that the first thing I think that the task force needs to do, though, is determine whether that document is public. So, members, keep that in your notes as we continue through this. What are some of the other questions I had here? Nope, that was it. Oh, just to also tell you, the ethics referral, once we make the referral with ethics, then it's with ethics. They have no responsibility they'll notify us when things happen, but it's not some joint or collaborative experience. Once we hand it off to them, it's all with them, so you're going to need to contact them directly for the the status.
Thank you.
Okay, that's all the questions I have.
And just as a point of clarification, Member Wolf, the subject would be homeless and work at DPH around the client population, which is a city homeless Department of Public Health issue. So there's actually a policy issue at a DPH site that is the issue.
So you filed a complaint of discrimination about other people, not yourself?
Including myself, because no worker should be exposed to hostile work environment or an unsafe environment, and that's what was happening at the DPH site. My discrimination complaint is that when I, of course, filed that, I was wrongfully terminated for that filing.
But that's all an HR issue.
Correct. But, I mean, if you mentioned no homeless, no, but the population actually is
let me read that paragraph so you understand the context. This is in relation to whether that group of people was a passive meeting body or not. So, notwithstanding the provisions of paragraph 4 above, which is a collection of solely employees that are created by the initiative of a member of the policy body or the mayor. Okay, so that would not be a passive meeting body. So, notwithstanding that, a passive meeting body shall include a committee that consists solely of employees of the city and county. When such a committee is reviewing, developing, modifying, or creating city policies or procedures relating to public health, safety, or welfare, or relating to services for the homeless. So it's specifically for the purposes of modifying, reviewing, developing, modifying, creating city policies or procedures, not the administration of those policies and procedures. So if they were discussing the creation or something about city policy, that could be it could then be considered a passive meeting body. The question is there any proof of that? Okay, I'm going to stop talking. Members, anybody else? Okay, so seeing none, let's move to rebuttals. Mr. Malloy, you have 3 minutes. So we'll just note that the respondent's not here to offer any rebuttals. Mr. Malloy, you have 3 minutes for rebuttal on anything that was discussed.
Go ahead.
Sure. I was just going to say that thank you for reading that, Member Wolf. The subject of me in relationship to the city is that Director Callahan established a local rule that the DA is aware of, that you can be called a nigger in the city of San Francisco, and her office will not administer the claim. And so when that language was used at my work site and I complained about it, it very well relates to the city's policy that she was not going to administer a claim when it was associated with that type of adverse language. So it very well could have been a passive meeting in that regard. Also, the City of San Francisco Human Resource Director, with all of her resources and knowledge and legal support, is more than capable of speaking to these issues, and her choice not to is indicative, as far as I'm concerned, of the admission of wrongdoing. So Mickey Callahan knows everything you all know plus 10. And so there's no excuse from my standpoint of not being able to articulate on these issues and then cause these questions. That's just an obfuscation, right? Bottom line, even if you do redact, you still have to show me that information under the Sunshine Ordinance and identify. You don't have to show me. We've had these conversations even earlier tonight in the other complaints. You just follow that law, and they're choosing not to do that, and that's unlawful. And the people have a right to know. Thank you.
Okay, thank you. Members, it's with us now.
I'd say the redaction doesn't look very good, so that's probably something I'd support a violation on. I think everything else, what I'm seeing is that they may have some attorney-client communications that are just not being produced, but we'll never really see that. We wouldn't even see it. But at least we do have a violation that we've seen with those redactions.
Okay. Anybody else?
I just have a question for Member Schmidt. Maybe you could, what would you suggest should have been not redacted in those redactions? I know that they're obviously referencing, was it 6254K for them? So what would you suggest actually could be redacted under 6254K and what could not be redacted?
Yeah, well, I would say that things like names and dates and I mean, redaction is sort of an art. You don't want to release so much that you've released a substantial portion, because then you've technically waived privilege. But I think that in any context, it's important that the redacted documents are enough so that we can see that it should be a redacted document, like the name of an attorney, the name of someone who the attorney would have a relationship of confidentiality with. And then you can presume that, okay, they're probably, we have to take them for the word that they're having an attorney-client communication which is privileged.
So, for instance, it would be reasonable to expect them to have revealed the sender and the recipient, for example, even if they redact the body of the message itself.
Yes. I think that you can reveal a lot in terms of like the header, etc., and maybe the subject matter, unless the subject matter is too revealing. But at least so it gives someone a chance to see, like, what is this document? What is, what's the basic, even though they don't see the substance of the document. And I think in this context, that's probably, if they're going to produce something, then they don't need to like black out every single. It doesn't make sense to me.
Gotcha. Okay.
Yeah, I believe me, I've seen it, and it's always like kind of obnoxious to see this kind of thing, and you end up fighting over it. But this to me looks like, no, that this is not good faith.
Well, this obviously looks like a, this is Chair Wolf, but it's obvious this is kind of email formatted, because if you look just above it, if you look on page 287 of the PDF or page 2321 of the footer, you can just look at the message right above it, and it's, you know, more or less formatted the same. I mean, if you want to follow it, you know, in that way, they redacted the links for reply all, and forward. Why do that? They redacted the to, the CC, and the from subject. That's not redactable. That's just part of a general format. You know, that kind of thing. But still, the key to this is withholding kept to a minimum, and no justification for the withholding. And I would add that in 6726, in the last sentence states, this work, the redaction work, shall be done personally by the attorney or other staff member conducting the exemption review, which means that it's somebody had to have been assigned to that. The work of responding to a public records request, preparing documents for disclosure, shall be considered part of the regular work duties of any city employee, no fee, blah, blah, blah. So I would say it would be interesting to know who actually did the redactions, and, you know, based on what, you know. So if it was Mr. Vong, who in the above message cited 6254K and 6254P2, Mr. Malloy would be correct in saying that he didn't go the extra step of providing the citations under 6727. I'm sorry, 6726, that each portion be keyed by a footnote or other clear reference to an appropriate justification for withholding required by 6727. So I would contend that there's a violation of both those. And then I would also cite 6721E for not sending somebody, no representative. (6721E).
As you say, Chair Wolf, that sounds like the beginning of a motion.
It is. Thinking out loud.
Are you proposing a motion?
Where requested by a petition, the Sunshine Task Force may conduct a public hearing concerning the records request denial. An authorized representative of the custodian for the public records request shall attend any hearing and explain the basis for its decision to withhold the records requested.
I second.
Okay, so I will start the motion going. I'm thinking violation is 6721E, 6726, 6727. I don't see Brown Act issue, and what was the other one here? 6724. Oh, let me just ask, Mr. Malloy, in your complaint form, you cite a violation of 6721. And it says existence-form-nature vanity dash subject and question dash specificity. What does that mean?
I had just gone through and looked at the ordinance, and so I was highlighting those key areas. So I was just basically saying I couldn't obtain any information as to the existence, form, nature, subject, question, specifics, because they blacked everything out. So I can't see anything to even know what that is. And then 6734 also.
Yeah, I understand that. We'll have to have a discussion about that. I just want to get to some of these other areas that you had cited. And 6724. Why 6724? Information that must be disclosed.
Yeah, litigation material, advice, analysis, opinion, communication. 6724, even if you cite litigation or attorney-client privilege, you're still supposed to demonstrate, to your point about the footnote, what advice, what analysis, what opinion, what communication are you basing that redaction on under CPRA, the Brown Act, or ethics? And they didn't do anything like that. So if they were going to claim that and they didn't, then they didn't do it based upon how the ordinance demonstrates you're supposed to segregate litigation material.
Okay.
As far correctly.
Yeah, we don't have any jurisdiction on ethics code, but with regards to this, the question is did they cite, did DHR cite any pre-litigation claim? I mean, there's no litigation, I think, with regards to this, right?
At that time, no. Because I submitted it November 20, last year, November? And then they went through the 2 extensions, which took them into January. And so, no, not at that time.
So then, under 6724B for litigation, public record subject to disclosure is 1, pre-litigation claim against city, 2, a record previously received or created by a department in the ordinary course of business that was not attorney-client privilege when it was previously received or created. Or 3, advice on compliance with analysis of an opinion concerning liability under any communication otherwise concerning the CPRA, Ralph M. Brown Act, Public Reform Act, Political Reform Act, any San Francisco Government Ethics Code or this ordinance. That's an interesting clause. Never noticed that one before. Okay. Okay, well, anyway. So I'll move to find in violation of 6721E for no representation through the complete complaint procedure, and 6726 and 6727 for withholding to a minimum and not citing in 6726 and 6727 for not citing by a keyed by footnote with justification for the redaction.
I'll second.
Who was that?
Highland.
Member Highland.
Okay.
Okay. Any other discussion on for this motion? Okay. Let's move to public comment. Any public comment on the motion?
Yes, please.
Go ahead,
hang
speaker.
On a second. Hang on.
Sure. Let me know when I may begin.
Yeah. Okay. Go ahead.
All right. Thank you. This is anonymous. So I agree with the violations, but I think there are a few more. Specifically, the 6727. There's an echo, by the way. The 6727 violation. I think it's not about the footnotes of clear reference. That's 6726. But citing 6254K is not a sufficiently specific exemption. Normally, you cite 6254K and then say which evidence code privilege. So when I get it, I get 6254K, comma, evidence code 954, because that's the attorney-client privilege, or say the attorney work product privilege, or official information privilege, or whatever it is. And that's because the requester does not have to guess at which privilege they want to cite. They have to tell you exactly which privilege under 6254K. And I think there is a potential 6724 issue here. It's 6724H, deliberative process privileges are banned. They cited 6254P2, and that's, sorry, government code 6254P2. If you read it, it contains a deliberative process privilege. I don't believe that the city can cite 6254P2 because of SS admin code 6724H. And finally, there may actually be an incomplete response here. If the complainant has personal knowledge that a meeting occurred between the department head of a department and anyone else, there must have been a record created under Prop G for that calendar entry. And when he asked for these kind of meetings about himself, he should have received the Prop G calendar entry for that meeting about him, if there was a meeting. Yeah, that's all. Thank you.
Thank you. Any other public comment? Okay, public comment is closed. Shall we, is there any amendments or anything we should add? Members? Okay, so I would like to add, based upon that comment, violation 6254K for not citing which evidence code provisions related to the privilege to withhold. And let's see, 67.24H, neither the city or any office employee or agent thereof may assert an exemption for withholding for any document or information based on a deliberative process exemption.
Seconder accepts.
For the 6724H?
Or both. For both amendments.
It does not prohibit disclosure. Yeah, okay. And I'll also, yeah, for same thing, 6724H for not probable,
Is that deliberative process for exemption?
Yeah. I mean, we could also include 6255 of the CPRA and just add that in there, since even though it's referenced. I mean, it's referenced in there, so I don't think it's not really necessary, I guess, at that point.
You're not including it?
Yeah, I don't think it's necessary because it's already mentioned in H. either as provided by 6255 or any other provision of law that does not prohibit disclosure. I don't think they rose to that occasion. They just cited it without any explanation. Okay, so we're adding 6224H.
What about 6254K?
6250 and 6254K is yes.
Mm-hmm.
Okay, so the motion is to find a violation of 6221E, 6724.
6721E. You said 62. I think you meant 6721E.
6721E.
Yeah.
67, 26, and 27. 6724H. And 6254K.
The evidence code.
The evidence code. Okay. And that we by that we would order under 6721. Let me find it. Where is it? Under 6721E, that the task force orders the custodian. Please let me finish. That under 6721E, the task force immediately orders the custodian of the record to comply with the person's request, and that this will be referred to compliance and amendments for monitoring.
The last one, 6254. I think you meant the government code, and I'm not sure if that's like a law that is violated here. I'm not quite sure how that got thrown in.
K reads.
It just is an exemption. I don't think it's like a disciplinary.
No, but they're supposed to tell you what provisions of the evidence code is related to the privilege of exemption, and they didn't cite it. They didn't say that it was, what part of the evidence code. Was it attorney-client privilege? Was it, investigatory? Was it, usually when people cite that, they will say, well, this is still under investigation, under this department, like it's the police department. They will cite that and say, this case has not been closed yet. When it's closed, then we'll make it public. So,
but the violation is of the Sunshine Ordinance that requires you to be specific and would say, well, you have to tell what part of K it is. Although I don't see how they violate the government code provision. They violate the Sunshine. I mean, that's just my take on it.
Yeah, I mean, that should be covered under 6727 already.
Yeah, I agree.
Okay, so you want to remove 6254K?
Yeah, just to make it a little cleaner.
Okay.
SOTF based.
Okay. Then the last one is then 6255. Oh no, we don't need to do that because that's already included in 6724H. Okay, so it's 67 sorry, 6721E, 6424H, 6726, 6727. Okay.
Second or accept?
You said,
Okay,
you
great.
said 6424. You mean 6724H? Correct?
6724H.
Yeah.
Yes.
Okay.
One question. Did we want to consider anything under 6729.5 regarding calendars? Since there was a potential meeting with the department head.
But that wasn't requested.
Wasn't it all records regarding Stephen Malloy? And if the department head had a meeting regarding Stephen Malloy, wouldn't that have been potentially calendared?
We'd have to find that we knew something that a calendar existed. I mean, that would be kind of speculative to think that is even out there.
I lost my signal.
Well, property calendars would be for department heads, right?
Yeah, but it's one thing to if you're requesting a calendar and it was being withheld, that's one thing. I think it's a bit of, for me, it's a bit of a reach. I think.
That's fine. Anonymous brought up. I think.
I think what I think the because of the 6721E for not sending a representative, we don't know if that was was that a specialized advisory committee or was it a deliberative body that was created? We have no idea what that group of people, who they are. Mr. Moy was citing the Brown Act because he thinks that it was a deliberative body, but we have no evidence of that without the respondent here to answer that question. And we're not in that level of investigative, body to be able to go out and do investigations. So we just don't have the ability to do that. I mean, we could also compel them to come to a meeting. And if they don't come to a meeting, then we could cite a 6734 for willful failure on that part of not showing up at all. I'm not ready for a 6734 unless somebody has a good compelling reason at this point. And I hear Mr. Malloy's reasons. I'm not there yet. Despite people being told that they shouldn't respond, the question is who. All right. Since we added those other items, going to reopen public comment. Sorry, Mr. Malloy, this is for just members of the public. Any public comment on the
Sure.
additions to the motion?
Sure, anonymous here.
Hang on. Go ahead.
First of all, I cannot believe how patient you all are hearing me over and over again. But with regards to this motion, I think this is the right motion, and it was speculative about the property calendar. I think if the person ever shows up, if the department ever shows up, you can find out whether that meeting took place. If the meeting did take place, the failure to produce that meeting entry in response to this request, you can always, when this comes back to the task force after compliance and amendments, you can always add another motion like you have in the past. So I think this is the right motion, and to leave Prop G for later. Thank you.
Any other public comment? Okay, public comment is closed. Are we ready for a vote? Sounds like it. Please call the roll.
Chair Wolf?
Yes.
Chair Wolf, yes. Aye. Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. The motion is a violation of 6721E for not sending an authorized representative to the hearing, 672026 for keeping withholding to a minimum, 6727 for not providing fee legal citations, 6724H for the deliberative process exemption, and 6721E, the SOTF immediately orders the custodian of records to comply with the request and refer the matter to the Compliance and Amendments Committee for monitoring. Did I get it right, Bruce?
You got it. Thank you. Okay. Thank you, Mr. Malloy. Let's move to our next item.
Thank you.
Item number 9, recommendations from the Complaint Committee regarding the existing new complaint form and complaint form submitted by a petitioner. I think Member Hinsey will be directing that conversation. She's on mute.
There she is.
Okay. Go ahead, Fiona.
Sorry about that. So just for a little bit of context, the complaint committee asked to look at a draft complaint form submitted by Anonymous. We did that in our last meeting. Victor and Cheryl then said that they would like to work with it and present us another draft. I understand that Anonymous itself has done another draft since then. So now Victor and Cheryl would like to again work on it, and probably provide the complaint committee with a copy in advance of our next meeting, and we will focus on that during our December 15th meeting, and we hopefully present something to you at our January full meeting. That's pretty much where we're at. If my members and Cheryl want to add on, but that's pretty much where we're at.
So what's...
I didn't hear Fiona's last sentence. What did you say, Fiona?
I was asking if anyone had...
comment. So Victor provided his own draft of a complaint form, which he updated today, and that will be circulated to the complaint committee members. And as well, Anonymous sent me another complaint form, both in PDF and Word version, which will be also reviewed by the complaint committee on the 15th.
Yep.
And Cheryl, did you get my edits?
Yes, we did. Yes, we did.
We did.
Okay.
Okay. And so we'll have it. When do you think we'll have a final on that?
We hope to present something to you at our January meeting.
I'm sorry, I didn't quite get that. It's a little garbled.
We hope to present something to you at our
January meeting? Okay.
Yeah.
Okay, great. Excellent. And thanks all for working on that. I think it's going to be very helpful. All right. Any public comment? Seeing no public comment, no action yet. Well, I guess we'll take action on approving it to form in January. So let's move on to the next item. Cheryl?
Yeah, I got it. Item number 10, Chair's Report, Public Meeting Review, Discussion of Task Force Members Reviewing Public Meetings.
Okay. I don't know. Vice Chair Yankee was there. You had been working on something, I think, right?
For regarding what?
It was a
With the election
commission, I think. Yeah, I think you're right. The Elections Commission.
Right. So we had sent the memo out to the Elections Commission, and I didn't look, in the last week or so, but last I had looked, they had still not updated their website with the meeting minutes. So that's something we might want to consider. How we want to go about that, since the memo's been sent and it seems like it hasn't gotten us anywhere with getting them to post their meeting minutes online.
You know what I did, Matthew, just so that everybody knows? I went online to find the commission secretary, and that's who I sent the memo to.
Mm-hmm.
But I will be at City Hall next week. I can stop in at the election department to find out if there's somebody else I should have forwarded this to. I mean, we haven't heard anything, so that doesn't sound right. So I have no problem following up in that respect.
Right. Maybe that's a good idea.
Yeah, sure. That was going to be my question. So we haven't heard anything at all from the.
I haven't.
Okay.
Yeah, I haven't seen anything, and Matthew hasn't either. So that's what I'm going to do.
Okay, great.
Sounds good.
Yeah, I'm looking at their website now, and I still don't see them. Well, let me look here. Draft minutes back to June. No, they're not all there. So yeah, we definitely need to follow up on that.
All right, I will do that.
Okay, great. And I will say that I've not had the ability to get in touch with the Planning Commission with regards to their video, telling their members to turn off their video during the meeting. Haven't had a chance to do that. Has anyone else had any experience with any meetings that they observed?
And just FYI, the Planning Commission may secretary, because the old secretary is now the secretary of the school board, so they need to deal with it. No transition over there themselves. So.
I didn't hear that, PM. Did you get that, Bruce? I didn't hear that.
I didn't get all of it.
Oh, I was
Fiona,
saying.
can you
I was saying that the Planning Commission secretary is now the MPA board secretary. As of ago, so they may be in transition.
Oh, Jonas Ionin?
Christine Silva.
So Jonas Ionin was the Planning Commission secretary.
Okay.
All right. Well, I can check on that. I want to make sure that he doesn't do it at the MTA board either, because he's the one that's been driving that. So.
Christine Silva's the MTA board.
Okay. All right. Very good. So it doesn't sound like there's any other reports, any public comment on this item. Seeing no public comment, let's move to the next item.
Item number 11, Administrators Report, Complaints, and Communications. Let me get that out. Does anybody have any questions? I included committee hearings for December, January, February, and March. In November, we only got 5 new cases. I sent out notice to respondents. We have come down a little bit. We've actually gone up. We've gone up in the number of complaints. Total that we have this month, it's a total of 115. Last month it was 106. Scheduling of annual retreat and orientation. Do we want to brush on that topic right now, Bruce? I have sent an email out to everybody with suggested dates. And I just want to alert you guys that it's out there, so when you get it, let me know as soon as possible so that we can schedule it. It doesn't necessarily have to take place on a Tuesday. And then let me know what time works for you, like if it's a Wednesday or Thursday. If you can't get out of work until 5, you know, we'll start it at 5:30 or something. But let me know, because Ruth would like to have this meeting here in December. Communications, we got a letter, an email from Anonymous. It was addressed not only to the task force, but members of the Board of Supervisors. We have minutes from the complaint committee, November 17. And we got our usual list of complaints and emails that I've gotten from members of the public, people asking about questions about task force. So, are there any questions I can answer for anybody?
So you responded to 111 emails and or phone calls since October 16th.
The 111 is emails, but that includes phone calls. I mean, I get people calling me all day long, okay. So it's no problem, really.
All right. So, any public comment on the administrator's report? Okay, members, any other questions? Okay, seeing none, let's go to the next item.
Item number 12, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Have at it, folks. Okay, all quiet on the Western Front. Let's move to the next item. There's no public comment because no members made any announcements.
Okay, item number 13, adjournment. I have 10:21 p.m.
So let's have a motion to adjourn. Hello?
I motion adjourn. Motion to adjourn.
I'll second.
Any a second?
Second by Vice Chair Yankee. All those in favor say aye.
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 Okay, ayes have it. No objection. The meeting is adjourned at whatever time you said. 10:22.
It just became 10:22, but that's okay.
Okay.
All right.
All right. Thanks, folks.
Good night, everyone.
Good night,
Victor,
everyone.
can you stay around for a few minutes?
Yeah.
Okay, make sure you stop the recording.
Yeah, I'm doing that right now.
Did you want me to stick around?
No, Victor. But thank you, Bruce.